We are now going to call to order the Thursday, March 12th, 2026 meeting of the Public Utilities Commission. We have 4 items noticed. Note that the third item, the Uri Storm Recovery Compliance docket, and the fourth item, the Energy Conservation docket, will not be done until after 12:30. So we're going to try to expeditiously get done with items 1 and 2 this morning. Chair Sieben is got some important activities she has committed to later today, and so we want to make sure we are expeditious, and I promise that. So those announcements out of the way, let's take the roll, Commissioner. Let's get, she doesn't need to be here for the roll. So, Commissioner Partridge, are you here?
I'm here.
Commissioner Hom.
Here.
Chair Sieben.
Here.
Vice Chair Sullivan.
Present.
And I am also present. There being a quorum present, we'll just have Mr. Manning formally introduce item number 1, and hopefully by that time we will have a live order writer. I apologize to the order writer for not paying attention.
Good morning, Acting Chair Tuma, Chair Sieben, and Commissioners. Today's first agenda item is docket number E002/GR21630 in the matter of the application of Northern States Power Company doing business as Xcel Energy for authority to increase rates for electric service in the state of Minnesota. This docket was last before the Commission on June 26th of last year. The question before the Commission today is what disallowance, if any, should the Commission make for top 10 executive compensation in 2021 Xcel Electric Rate Case? Parties and staff are available for questions. Thank you.
Parties, why don't you start making your way up here? No big rush. And then while we're at it, let's just get the old introductions out of the way. So we'll start here. Mr. Swanson, go ahead and introduce you, and we'll just go down the line.
Thank you, Mr. Chair. Good morning, Chair and Commissioners. Eric Swanson from the law firm of Winthrop & Weinstein on behalf of Xcel Energy.
Good morning, Chair Tuma, Commissioners. Richard Dornfeld, Assistant Attorney General, appearing today on behalf of the Minnesota Department of Commerce.
Good morning, Chair, Commissioners. Joey Cherney, appearing on behalf of Residential Utilities Division.
Good morning, Chair Tuma, Commissioners. Brandon Crawford with the Citizens Utility Board of Minnesota.
Any word? Looking to council, do you have any problem for us to continue with questions, or do you want order writer to be here? We can continue. Okay. That's what I apologize. I should have looked over there and I didn't. So
we need the order right here before we make any sort of motion.
Motions and stuff like that. So I think that's what my plan was. We were not going to do opening statements. We got a pretty thorough reading of the record more times than we would like to, and so I think we'll start with questions. Commissioner Sieben.
Actually, I have comments, so if someone else has questions that wants to begin.
I don't have any questions. Commissioner Hom.
Thank you, Chair Tuma. For the company, why can't you guys recording the timesheet of your top 10 executive like what you do with your holding company employee serving NSP? So my understanding is your holding company employee serving NSP or any other operating companies, they are billing actually NSP or other operating company. In that process, you are actually recording some time. Why can't you do that for your top 10 executives?
Mr. Swanson.
Mr. Chair, Commissioner Hom, that isn't an issue that was discussed at all in this record, so I'm not sure I can respond.
Yeah, thank you. But isn't it common sense? We are in dispute this for a while, right? So I don't know how long. It happened before I became commissioner, so it's been a while. So why can't you find more productive path rather than keep fighting over this.
Mr. Swanson.
Mr. Chair, Commissioner Hom, the company very, very, very rarely appeals a commission decision. It is not the normal course. In this case, we felt it was important for a number of reasons that I'm happy to get into, but I don't know that that really matters for your decision today. The company only appeals when it feels it's a matter of importance enough that it needs to.
Yeah, that's what I meant. It's so important. Why don't you find a more productive, easy path to resolve this issue? It's not a one-time issue. It'll be an ongoing issue, and that's why I'm just wondering whether the company already is doing that path or not. Not just for this docket, but we have a pending rate case, and then Xcel will keep filing rate case for a while. So why don't we find a more positive path?
Swanson.
Mr. Chair, Commissioner Hom, that helps. In this case, frankly, this particular issue was never one that had been contested before. It is now a contested issue, so we have to find a constructive path forward, and we'll do that. But in this case, this simply hadn't been an issue prior. So that's why you have the record that you have in this case. Next case is going to be very different. It's been a contested issue. It will continue to be discussed by the parties.
All right, thank you.
Mr. Sullivan, I thought I saw your hand. So.
Yeah, you did. Thank you, Chair Tuma. And your answer there, Mr. Swanson, the second part kind of gets to where I was driving to, but it feels to me, and I'm wondering why the company did not go down the route. I mean, we have a really good example in the state of utility executives who do not have a profit-seeking or shareholder-seeking motive in cooperative utilities. And I would have found it more helpful had the record developed around, what is the median salary for a cooperative executive, for instance. I don't think municipal utility is quite on point. I mean, it's similar, but they're city employees. But maybe even an amalgam of municipal and co-ops kind of gets to a number that I feel would be kind of just and reasonable, kind of in that zone. But I'm just curious why the record didn't develop in that route.
Mr. Swanson.
Mr. Chair, Commissioner Sullivan, the record didn't develop in that route in this case, in the 21-630 case, because it was never an issue that was raised by a party. The company provided similar information to what it had always provided. The issue was never joined by anyone, so there was never any reason, essentially, for the company to come forward thinking this might be an issue that would be raised. I think going forward, you'll see other information like that in other cases.
Okay.
I have no questions. Commissioner Partridge, any questions, thoughts? Okay, Commissioner Sieben.
Thank you, and thanks for that discussion, Commissioners and Mr. Swanson. And I just remind parties that, we made this decision for the 2100 rate case at the time when the state was coming out of COVID. There was a tremendously large rate increase that was before the commission. And in the record, there were multiple parties and members of the public who said, why are, in this case, Xcel executives getting paid X amount of dollars or whatever they'd say about top 10 utility compensation. And again, just to reiterate some of the facts from the case, the law requires Xcel to file top 10 utility executive compensation. It was not filed at the beginning of the case and only came up at the tail end, when the commission heard the facts.
After the record was
After the record was closed. Well, the record wasn't closed, but it was at our oral arguments. And, you know, our orders sometimes help explain what commissioners were thinking. And I think our order in this case did get at some of the thinking behind around my view of the case, and reflected the record in that it said, like, top 10 utility executive compensation in this case is excessive for ratepayers to bear as much of the burden as was being requested by the company at the time. So I think it's a fair discussion to have in the future about, you know, what should the proxy be that's an appropriate measure for utility executive compensation for ratepayers to bear that portion. And that was discussed in the record by different parties, and I appreciate that. Today, I'm going to support keeping the decision option 2, which is to keep the top 10 executive pay at $150,000, because that was both consistent with the record and our order. And I think it's also fair to point out that when Xcel did appeal this, then the Court of Appeals came back and said the commission was right to deny, or was within our authority to deny a portion of the compensation for the company's 10 highest paid executives. And the issue on remand, or the issue that was remanded back to the commission, is about why did the commission pick the governor's salary. And that's what I think is consistent with, at the time, both what I was thinking, what was reflected in our order, and then now was also well developed by the parties in the docket that's before us now. So the thinking, again, and I can kind of walk through some of my notes here, was that the Court of Appeals said that Xcel sought rate recovery for a portion of its total compensation for its 10 highest paid executives, specifically about $7 million for each of the 3 years of the multi-year plan. In the contested case proceedings before the ALJ, the vice president of an Xcel affiliate testified that Xcel sets compensation for non-bargaining employees near the median of similar positions in investor-owned utility and non-utility companies. There was no testimony or evidence specific to the compensation for Xcel's 10 highest paid executives. Although Xcel was required by statute to file a schedule itemizing expenses for its 10 highest paid execs with its initial case per Minnesota Statutes 216B.16 sub 17A5, that information was not filed until after the contested case proceedings, when the matter was before the commission. The ALJ did not directly address the issue of compensation, and they go on, and again, it cites the Court of Appeals opinion, cites our order. Having received more than 20 public comments on the issue, the commission decided to specifically address exec comp in its final rate order. It determined that Xcel failed for 3 reasons to meet its burden to show that charging ratepayers $7 million annually for compensation of its 10 highest paid execs was reasonable. And then it goes on to explain those 3 reasons. So again, like, I think the issue before us today is, what is the proxy we pick for those 10 highest paid executives where Minnesota ratepayers should reasonably be expected to pay a portion of their salaries. I'd make it clear again that I thought I was clear, but probably wasn't at the time, that by selecting the governor's salary or the approximate salary of the governor at the time, that in my mind was representative of, like, he is the highest elected office holder in the state. And yes, there are executives in the state who are paid more than that. It's approximate and close to what commissioners make, for example. And, you know, again, taxpayers, and this was helpfully put into the record by, I think it was Cub, taxpayers pay the governor's salary, and just as ratepayers will pay a portion of the Xcel's 10 highest execs, about that equivalent. So I don't know if that's enough rationale, but that's what I was thinking at the time, commissioners. I think we were right to try to limit the expenses that were charged to ratepayers in the face of a really high overall rate increase. It doesn't bring me like any sense of satisfaction that, as Mr. Swanson said, that portions of it were appealed, because I know that's unusual, but I do think it should be usual for our utilities that we regulate in the state of Minnesota to deal with this question of what is a fair balance between the amount that ratepayers should pay towards executive salaries versus what expense should shareholders pay. And because we authorize their rate of return, it is expected, again, that some of that profit will go towards executive compensation, and that's totally fine in my mind. So that's kind of like the thinking of why I landed on decision option 2, and I appreciate the further analysis that the parties all put into this record.
With that, and Madam Chair, I agree with your position, and I wanted to thank the department, the OAG and Cub, for their input there, because it pointed out the record that we all knew. And again, if we would write an order like I think the court wanted us to write, we would end up with a 1,000-page order like FERC does. And so we try to avoid that on occasion, and just think that sometimes just people rationally will look at the record and say, yes, they had to come up with a proxy. It was a tough choice, and here's a proxy. And I think that's what you're saying, and that's what I think you guys laid out in your filings, and I appreciate that. We have a robust record. We'll have a robust order, I know, and I apologize, Ms. Kaler. I didn't want to put you on a bad spot, but it is something that we have now, and so I'm very, very comfortable that we have dealt with this. We dealt with it before, and we're going to deal with it right going forward. I just was kind of struggling with it, but I really wanted to tell you guys I appreciated your filings, read all of them, and it was very helpful. So with that, all those in favor of the motion signify by saying aye.
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 Those opposed, same sign. Motion passes unanimously.
Thank you, Mr. Chair.
Thank you.
Mr. Chair,
Yes.
I may need a couple minutes. I didn't realize my monitor's not working, and I assume we have pictures. Sorry about that.
Let's take a recess until hopefully 5 minutes. It's going to be enough, but we'll go from there. So 9:25. Brian, get up there. Yeah, just Wait, we gotta get live first. I'm going way too fast. Okay, Mr. Ecknes.
All right, good morning, Commissioners. Item number 2 is docket TL-25-389 involving Big Bend Wind LLC and Great River Energy. It's in the matter of their application for a route permit for a 161 high voltage transmission line and associated facilities in Martin County. Questions for the Commission: should the Commission require an addendum to the environmental assessment? And if an addendum is required, should the Commission authorize the issuance of an environmental assessment addendum scoping decision? Third question: should the Commission issue a draft permit, which was attached to the briefing papers, and should the Commission request an ALGA from the Court of Administrative Hearings to conduct public hearings for the project and prepare a summary of public testimony? Just want to note that yesterday amended decision options were filed by Commissioner Tuma, amending option 2 and a new decision option number 5. With that, I'm available for questions.
We'll go right into questions, and I will start. Why don't you put up the first slide and I'll just give you a little bit insight of my thinking, Ms. Brusman. Okay, I was asked whether this should go to consent calendar, and so I take seriously my role to check these things and make sure that when a citizen has an alternative, we take it seriously and look at it. Here's a picture from the Beacon Maps county records. I don't even know if that church is still standing, but it's the Cedar Church. They really want you to notice the church. It is cute. It's the classic old, churches you see out in the countryside, not far from where you grew up. Beautiful trees around it. Had the line gone over it, we would have taken out about 4 of them, would be my guess. And the cemetery goes right up to the road. The road is to the north. That's 220. But what you see on the left there to the distance, that's what I wanted you to pay attention to, and that's a turbine. This area has lots of turbines, the competitors, not you, okay? And it's a very active area. It has a 345 kV, has a peaker plant, big substation within a half mile of this church, okay? When I started reading it, I wanted to find out what's going on here. Is this a crazy church lady who lives in Minneapolis and goes down there once a year and doesn't want to see a power line? Then I would have been fine with it. But here's what started to unravel the whole thing, and I'll just go through it quickly. You'll get your chance to respond. I don't have, to my knowledge, the landowner that made the request online, so it allows me to go quick. I don't have to do the old, this is the rabbit hole you fell down and fell into, and this is who we are, so we can go right to the heart of this, and I'll just tell you and your client what started to unravel, okay? And the first one was on page 4 of your filing on January 26th. You listed 5 very compelling reasons why I should not look at Ms. Scholl's alternative, okay? Very compelling, and I said, okay, I want this to go to consent. I don't need the staff to do extra work. Let's keep going. I want go, 216I, let's move, okay? And on there you said, go to the next slide, Ms. Kahlert. You said, routing the project on the south of the side of the 345 kV transmission line, that's the yellow line, okay, would put extension projects close to an existing residence within 200 feet of a farmstead and not along an access road. Okay? I looked and I looked. It's not there. So unless you can point to me somewhere where that actually happens on her route, not your route, her route, okay? And that's where it started to unravel, okay? I really like you to be truthful to me and honest and pay attention to your maps, okay? Because I will look at the maps. I will go to Beacon. I will figure out there where they live, okay? You didn't do that. When you gave that information to Ms. Brusman, okay, because I'm pretty confident Ms. Brusman's not going to give me misinformation, okay? That person doesn't exist. Ms. Brusman, you're looking frowning with me. It's the Nurowski family to the north, okay? If you would have gone your route, okay, it would have done that. But we're not going your route. We're looking at Dana Scholl's alternative, okay? And it does not go, her alternative does not do the same thing your route would have done to their neighbor, okay? And that's where it just started to spin, okay? Go to the next slide if you could. Oh, by the way, the Norowski property, was you got that map on there? See, it says, see the details? Go back to the one you, sorry about that. It says, see details? That's their residence. And if you see, if we would have followed and done a route along the yellow line, it would have impacted their property, okay? But Ms. Scholes did not recommend that. She recommended a different route that is over 700 feet south of where her neighbors are and would not have impinged on their property at all and would have been not even visible from her property. Okay, now the next slide. What bothered me when we asked you, did you talk to, and I did an IR to find out, did you go talk to Jeffrey and Dana? Okay, and I'm assuming you have not talked to them since we sent in you sent in your information to me. Is that correct?
For the record, Christy Bruisman appearing on behalf of Big Bend Wind and Great River Energy. Commissioner Tuma, that's correct. We have not had further conversation with Ms. Scholl.
The reason I wanted you to do that, because I wanted to see if you just at least sat down with her and said, okay, let's talk about your alternative. To me, that's what should happen, okay? Like I said, these people, and you'll see, these people have putting these stuff on their property. It's not like she's, best that I can tell, she's just a person who lives a half mile south of the church who farm, okay? And so it's worth listening to, okay? Now, what I suggest in my alternative, just so you know, just want to confirm with you, if we were going to do a reasonable alternative for her, we should modify it. I'm not convinced I want to do an alternative. That's a very close call, okay? But if we're going to consider an alternative, somebody probably should have sat down with her. Echoes of Lake Town here, okay? Should have sat down and said, you know, the better route here is to put the poles on field lines, because Mr. Hansen, S-E-N, okay, his field actually crosses his property line. She went down the property line. I'm just trying to make her route reasonable for consideration. So don't need to get into the debate about all the other stuff. We're going to get in a lot of other things here, but I think if we're going to do a route, an expanded route with here, okay, and placing the poles for the alignment makes more sense than crossing a field and having to put poles in the middle of field. Would you agree with that? This would make this route at least reasonable to consider. Doesn't mean we have to consider it, because we have a choice to kick out ones that we don't think substantially improve. I got all that, so you don't need to make the argument. I just want to know, this is probably the route. If we were going to do that, that we should have probably told Ms. Scholes, this actually makes it workable. Would you agree with that?
Commissioner Tuma and commissioners, I would not. So we did have extensive conversations with Mr. Hansen. So that's his property that we're paralleling here.
And that's information I asked you to try to give to us, and I didn't see that, okay? And that's the frustration I have, okay? But if we were going to do this and Mr. Hansen was amenable, okay, I'm not saying either is or not. That's not the question I asked you, okay? If we were to go out and ask the neighbors to compare these two routes, just doing this small modification, this should only take us 1 second. It should be simply yes, okay? I don't know what Mr. Hansen is going to say, because I don't know. We haven't showed him this route, okay? And so unless you tell me now that you have been showing all these landowners, Mr. Hansen and Mr. Anderson, this particular route, okay, that might change things, okay? So did you show him this particular route?
Commissioner Tuma, the particular route that you have on the map with the angle, we did not. We did talk to Mr. Hansen about an alternative.
Just answer the question, okay? I'm going to be tough here because I don't have Ms. Scholes here, and I got to get moving, okay? I've been told to move, okay? So answer the question. This just does make it better. Okay, it doesn't mean Mr. Hansen's going to want it, right?
Commissioner Tuma, we have not shared the diagonal with Mr. Hansen that you filed yesterday at 4 o'clock.
All right. Now go to the next map. We'll just try to be quick here. So here's Mrs. Scholl's route with property owners on it, okay? And on your filing that you gave me, which you gave on the 26th of January, you had 3 very compelling reasons why. And the compelling reason was it essentially crosses diagonally, okay, along the 365 and would mess up the farm field for the farmer who owned that farm. And we would never want to do that. That person would not want to do that at all. And then I tried to get some more clarity on who owns what and whether you talk to Jeffrey and Dana. And then you sent me back a map with where Jeffrey and Dana own. I don't know what their estate plan is, but I can tell you that that field that you were trying to protect is a complete field with 3 separate parcels, just like Mr. Hansen's parcel crossed over his field crossed over his parcel line. And so we have a single field that's all shoal at the last name. Jeffrey is a part owner of one of them. The other 2 are in trusts, okay? Here's what's interesting. When you look at the Shoals property, the actual Dana and Jeffrey, a half mile to the south, 3 big pole barns, a huge grain elevator operation, 8 grain elevators and an elevator to toot. So pretty good chance that Jeffrey could be, I don't know that, if we only had a process to figure that out, okay, like talking to them before you bring us a petition, he might be farming that land. He might actually say, Dana, you're right. I'd rather farm around those poles, those 3 that concerns that you have. I'm okay with that because I don't want it next to the church. So did you have that conversation with the farmer who farms the Shoals property that you were so gun-ho with 3 very good points that would have been Trump, boom, I gotcha, okay? My 4 of spades beats your ace in any day, okay? That would have been bam. Did you talk to the person who actually farms that property?
Commissioner Tuma, we did not talk to them, and I would love a chance to explain why.
Okay.
So first of all, I just want to reset a little bit. I know that you're a very little reader, and I appreciate that you love routing and citing almost as much as I do, maybe more. But if I'm looking at page 4, the language that we sort of started with, and you said this is where it unraveled, the first paragraph talks about the shoal alternative, the blue line on your map. The second one says it parallels for a piece the alternative route that we rejected in the application, that we put in our application as a route alternative, capital alternative route from the application. That's the defined term. Those 5 points are the points we raised in the application. So I appreciate that they don't...
As to the Shoals property, I read that as to saying Shoals is bad because we looked at this already and it's bad, and you made me to believe that it was going to affect that piece of property, the Narowskis. That's, if you read that differently, if I read that wrong, my dyslexic brain didn't see it right. But when I read that paragraph, I am led to believe you were telling me that Mrs. Shoals' alternative was going to mess up the Narowskis' farm, and that's not what happened.
And that was not our intent. So
well, that's what it read.
I understand and appreciate that, and as I look at it, the 2 capitalized terms are very close, and so I can see how you would have read that to be all 5 of those points apply to this short segment. We wanted to convey to you that we looked at this alternative route that parallels the 345, and here's why it was rejected. So I apologize if that sort of got the unraveling going, but Big Bend has worked extraordinarily hard over the last 5 years to pull this project together, both the settlement with the tribes on the wind farm, and this area, as you pointed out, is really complex. There are not only the landowners impacted, but there are 2 different separate wind farm owners that have interests here. So it's not even just a 2-way negotiation, it's actually a 3-way negotiation. It took the Big Bend team over 2 years to negotiate with Avangrid, the current owner of the existing wind towers that we're looking at, to be able to talk to the Hansons and the Andersons about putting a transmission line through these properties. And they did that successfully. And really kudos to both companies to sort of resolve a problem that would otherwise have been before the commission, and to be able to do so to follow existing road rights of way. So we're along 40th Avenue and 220th Street for the most part, except for this cemetery. We would not be able to, and here's why we didn't get to the Shoals. We would not be able to put the wind turbine, or the transmission line overhanging or with blowout along the Narowskis, I gotta get my glasses on, The Wayne Hansons, so those two properties, right after we get off to Brian Hanson, your diagonal, the properties that come in sequence, we can't overhang those with the transmission because we don't have permission from that wind farm owner to do that on those properties, which means we'd have to offset on the shoal alternative, which is in the record. We have to offset into the farm field. And we talked to Mr. Hanson and Mr. Anderson, because again, they were along our proposed route, about the possibility of being in that farm field, and they said no, right? We want to be along the road to minimize the impact of their farm operations. So we didn't get to the shoals, any portion of the shoals, because we couldn't get past the Hansons and the Andersons to get over there. And so we did have conversations. We had conversations over multiple years before the shoal alternative was a thing to get there.
And I read this very carefully. What I want to see is that you talk to those landowners and you provide me that information. It's helpful today. Okay, like I said, it's a close call, but I scoured this record carefully. Okay, and that information, Mr. Anderson's opinion here to me is the most important opinion at all. I would like to hear from him. The other guy, I didn't want to hear from you. You wanted to put it over the cemetery. I don't want to listen to that goofy talk. Why don't you simply make sure you communicate that information to us? Be transparent. What I get is these 5 points, okay, and they don't hold up, okay? And that's what unravels this. This should have gone to consent. You should have talked to Ms. Schultz. You should have told her all of this, okay? Privately, sit down with her, explain it to her, and she might have even written us a note saying, well, after looking at it, it's fine. I know she doesn't speak for the church because the church board, okay, seemed to be okay with this. At least that's what you implied, okay? Let's go to the next 2 slides. I have another question that just is angering me.
And I think we can resolve that one easily. So
okay.
I'm glad you have the call-outs.
So here you say it's going to be too close, okay? I would 125, and then I came, okay, so what's happening here is there's a 345 kV line where it says 125 there, okay? Right next to if you look very closely, you'll see the power line, okay? And so you need 125 for the other one, and then this is again Beacon, it's not accurate, it's just giving me an estimate, okay? And it's 550 feet, okay? That could be a problem, I don't know, I mean, these things throw ice, they do things that are bad, okay? So to me, that would indicate that this could be a problem, okay? Now go to the next slide. This is where it started unraveling. You have to just explain it to me, what's going on.
I'd be happy to, Commissioner.
So go to the next slide so the other commissioners know what I'm talking about. The next slide, if you could, please. And zoom in on the picture, if you could. Not that one. Sorry, my apologies. It should be the one with church. I don't know what's going on there. Go back up one, another one more. My apologies. Okay, and then zoom in on the picture. So I have 2 questions here, okay? So this is the V that goes around the church. You made it longer, which means to me that likely this is going to be a much taller structure, okay, where it says 58.33, okay? This is an exact copy of what you send in your later IR response. For some reason, it does this little flat line across the road. I don't know why, but it doesn't matter. But I would think that you're going to have a bigger structure there. And when you do that, you're within 510 feet of a turbine, which doesn't seem to be any difference. You let me think that this is a bad thing on the Shoals property, and here I end up 510 feet from there. I want them to understand what I'm seeing before you answer it, because I know we're tracking and
Perfect.
Having a fight. But when I saw this, I started thinking bigger tower. Okay, so bigger tower. Okay, and then why didn't you just cross over the north side of the road? Okay, and now you're probably going to tell me that developer wasn't going to do it, but again, you didn't have that conversation, the best that I could tell, because that owner is a Shoals. So I'm struggling why we went to this effort to work with Mr. Anderson, which is fair. He's a very kind guy. I appreciate him. He deserves an award for being the most helpful person on the planet. Okay, but I don't understand why you just didn't go to the north side of the road. So why didn't the chicken cross the road? Okay, and then you know, what's the big deal here? Because 510 is actually closer than what the other one would have been.
So if we could go back, if you wouldn't mind, Kate, to the slide before that. So as I understand the drawing that you have in the measurements, Commissioner Tuma, you have 550 feet from the existing 345 line to the existing tower.
No, it's 125 plus 550. You said that you needed 125 distance from the other structure. So I took that as meaning the center line needed to be 125 feet from the other 345 kV. That's what your application says. I read it closely, so I did 125, and then the 550 is in addition to that. So it's a total of 675 feet from the actual structure.
I can't verify.
And I can't either. This is just me trying to truth test what you provided, and it doesn't look like it's any better on the Mr. Anderson alternative than here.
So our math, right? So we've got the existing 345 kV line that's shown here. Again, you go 75 feet in because that is the 345 kV right of way. Then you add our 50 feet, right, in, so that gets you the 125 feet between pole and pole on those two transmission lines.
So I actually did line to pole, but that's...
So our math has that being 425 feet.
If we just had a process to figure this out.
Well, but I'm sharing with you why we said that it was too close.
But then I'm looking at it going, okay, you do Mr. Anderson's suggestion, and it's the same deal. So I'm trying to figure out if that's okay, why isn't this okay? That's the problem I'm having. I have a line here that you say that you're going to route, and I could come back to me and say it's not going to be okay after I do an EA because it's too close to whoever owns that wind turbine.
Commissioner Tuma, that turbine is approximately 412 feet tall, 1.1 times tip height, which would be the average setback or the requested setback, and in this case, sort of the required setback between our transmission line and that wind tower would be 450 feet. Our math says we don't have room with the agreement between those setbacks we just talked about and that existing transmission line, which is why we flagged it as too close. The second figure, where you have 510 feet, right, that is our transmission line pole, and so that is greater than the 1.1 times tip height from that existing tower.
But you don't own that existing tower, so you have approval already from that wind farm to put it there.
We do.
Okay. That's helpful. I didn't see that. Okay, and this is my frustration when I want to send it to consent and I'm not seeing this information. Okay, it affects my ability to make a decision that respects Mrs. Scholes. Okay, so go to the next slide if you could. Here's the last one. Okay, not all the way down to the map, the one that you were on before. So when I'm given an alternative, and again, if it doesn't work, it doesn't work. Slide down to the next one. It should be a map of after the. Keep going. Keep going. The next one. Next one. There you go. Up one. So I looked at it. I've got to look at if that route is substantially better. Okay, and one of the things that you're all worried about is cutting down some trees along a fence line. So that's a legit. I don't know what they look like. They could be buckthorn or they could be beautiful magnolia trees. I don't know what they are because I don't know that in the record. But here, if we were to follow Ms. Scholl's route, okay, to the lower left, okay, you see the property line there, okay, it would cross Cedar Creek one time. It's about 200 feet wide there. Now, to be fair, neighbor Hanson, S-O-N, looks like he has some set-aside acres there that it would follow about 800 feet along. And so Mrs. Scholl's alternative would impact Cedar Creek, okay? Now, if you go to the next map on the bottom, your route goes into Cedar Creek, crosses it 3 times. You have a corner pole on some sort of wetland island in the middle of Cedar Creek, and then it travels along Cedar Creek for about a quarter mile and crosses very close to what looks like a duck pond that Mr. Anderson made. Apparently doesn't bother him. I don't have the other map here, but actually it goes across the road from Mr. Anderson, okay, and within 200 feet of his back deck. I struggling to understand why Mr. Anderson would want this to be the case, okay, and why the DNR would be happy with that. And that's why I wanted to see that you were making some communications. Had you told me Mr. Hansen is not going to do this, it would be nice to have that information in the record, okay? Have Mr. Hansen say that to me, okay? Just like you had or maybe he did it on his own, Mr. Ebling, who said, I would rather have it over the top of the church, okay? I mean, I don't know that, okay? I want to talk to these landowners. This is only 2 miles. They're all neighbors. I want to know that you've had those conversations. And it irritates me, just like in New Prague, where when we send people out there to go talk to them, they didn't talk to them. And that's what worries me. And simply just having conversations with Dana Scholes would have solved this problem. If I know that, and then you could have put in the record that Mr. Hansen absolutely will never let it cross his field, okay, between his 2 pieces of property. That been in the record, all this other stuff that you were telling me that it did not truth test wouldn't have mattered. You see my frustration?
Commissioner Tuma, I definitely hear your frustration.
You better see it, because this is what your clients need to bring to me. You want to go consent, okay? You need to answer those questions. Those are pretty reasonable questions, okay? Had I known Mr. Hansen, absolutely no way. That's the trump card. Your 4 hearts beats my ace of spades, okay? Now, I like Mrs. Scholes' route, but if it doesn't work, it doesn't work. We don't want to force you to do eminent domain and all that stuff. We want volunteer easements. But you got to communicate. I've talked to these people, and I don't see that, okay? And frankly, I think the tower is too high there. Why don't you just work with the church to get them registered, okay? I've done that before as an attorney. It's not the end of the world. I guess it's an unknown possibility. So if Mr. Anderson can agree to it, I'll put a taller tower up and put a distance of 1,200 feet. That's what you're going to do, a taller tower, when I could have worked with the church and just paid the church. Those are things that I see. So I'm inclined to give you space here, but I also might give you, say, go talk to the church and see if you can do a less than a taller tower, because it will be a taller tower, right? Okay? Go ahead, answer.
Chair Tuma, Commissioners, yes, it will be a specialized tower and taller tower because of the larger spans to avoid putting poles on an angle in the agricultural land.
And you could go over, not the cemetery, but you could go over the church property with an 800-foot span and avoid the cemetery. That's the way I wrote it out.
So, Commissioner Tuma, I don't think you actually can, because the right-of-way itself would be over burial sites. As you pointed out, those the cemetery plots are right up to the transmission line. We looked at this extensively and carefully. Big Bend would have preferred to pay the church. I think the church would have welcomed the dollars, and we would have preferred a straight line. But we cannot finance a multi-million-dollar project with an unknown as to the land rights, and we cannot, even whether it's a private or a public cemetery, we cannot cross over a burial plot. Think about it from a right-of-way perspective, right? There's span. We think with spans, it'll avoid. But you have maintenance, you have the ability, you have the need to go back and forth between those. And one way or the other, that's what the law says. And we looked at it very, very carefully. We looked at over extensive amounts of time and spent an incredible amount of effort to see if we could make that happen. That's in the record. You can see it in the correspondence back and forth with the cemetery that we put in our information request responses. And again, Mr. Hansen was gracious. He was wonderful to work with.
Mr. Anderson
was gracious and wonderful to work with, and he has agreed. He did not want poles in his agricultural field. We respect that. We found this, we were able to design this, agree to it with him. Again, I don't think there's any better evidence that the landowners in this area support this route than the fact that we have 100% voluntary easements for the route that are proposed in the extension project in the application. And so,
did you ask the people to the north of the road?
Yes, which is why we're where we are.
And they said no.
Yes.
Who did you ask?
We have had conversations with nearly all of the landowners in this entire area. You recall that there were two potential
When
routes.
Ms. Scholes calls me back and says, I don't think they did, I can say definitively on the record that you talked to the Scholes who own the property to the north, the Scholes who own that property, which is the same field as farmed by all Scholes, okay? It's a Scholes property. You would have to go under the Scholes property next to Mr. Anderson to get to the north of the road. So when she calls me up and says, wait a minute, I went and listened to it and that's not what I heard, you are definitively saying you talked to the Scholes who owns that property to the north and they said no.
I can't, as I sit here, tell you whether we've talked to Stephen Scholl.
I didn't say Stephen. I said the
That's
Scholes who
that's
own the property
Scholl
to the
that
north.
own the property to the north of the cemetery. Commissioner Tuma, I've got a map here if it would be helpful.
Yeah, I know.
Property owner
It's a
names.
trust. And Stephen lives in Denver. I got it. Okay. So, I mean, I understand that. But you have not talked to Stephen, or you have talked to him?
We have talked to all of the landowners here. I can't tell you if we talked to Stephen Scholl as I sit here today, but I can tell you that this was the line that we had voluntary easements for 100% from where it departs the existing route that you've approved to the substation.
It would make more sense to me to go to the north side of the road, just like you crossed over the road for Mr. Anderson. I don't know why you didn't do that. It's not clear in the record to me why you didn't do that. It would be less expensive. It would make more sense. We do it all the time. So it's still confusing to me why we shouldn't just give you an expanded route width and tell you to go talk to those landowners and you can put it in the record, because in that situation, we wouldn't have to do a new EA. We already know what's going on there. So would you do that? At least go talk to the people to the north to see if you can avoid this V and a bigger structure right next to the church?
Commissioner Tuma, we will attempt to talk to Stephen Scholl, the property to the north of the cemetery, and add that to the record for the public hearing, if that would be helpful.
That would be helpful. I don't think I need to do an alternative, because you can come back here and say, look, we've talked to them and we have an hour route that the landowners agreed to prior to the hearing, and then we'll deal with it when we deal with it. So, but you're going to go have that conversation. I know it won't go anywhere because typically that's what happens, but at least we're having the conversation and they know we're listening. My apologies, everybody. Got worked up about this. Mr. Hahn.
Thank you, Chair Tuma. First of all, I really appreciate Commissioner Tuma on this, because I'm the gatekeeper of the consent agenda, but I think everybody sees today that I think Commissioner Tuma is the actual gatekeeper on the CN and the routing and siting. So I think we are checking every detail. So I think 216I to work. Your applicant has to be very proactive and making sure that you are working with our staff to bring the better record to the table so we can be more comfortable to make it through the consent agenda process. So I have no concern sending and then signing off consent agenda if Commissioner Tuma is okay with the routing. And he is really looking into every detail above and beyond what I typically check on the consent agenda. And the second, I really appreciate all landowners around this area. I saw this map, and also I heard from our expert that this area is having a lot of infrastructure burden. There is a pipeline, transmission line, wind farm. I really appreciate every landowners hosting this infrastructure over there. Overall, I have a concern with this conversation that I think we have to be very careful making this neighbor to fight over neighbors. So that's why I understand your frustration. I agree with you in big picture, but also I want to make sure that this is not becoming the neighbor versus a neighbor. I hope applicant does better job, not framing it that way. When Commissioner Tuma tells you, go to your work, that doesn't mean that you are making these neighbor to fight over neighbors. And also, I think churches are trying to be very graciously taking this hit, but also I think we have to pay respect to every burial ground. So I think hopefully if nothing works, we better have a better mitigation plan to protect the view and the property So by planting the better mature trees or any other way to make sure that the burial ground is protected.
And thank you, Ms. Rusman. I appreciate you putting up with me being irritated about it. So with that, I would move decision options 1, 3, and 4 with the understanding that they're going to go talk to the landowners. Oh, sorry, I didn't see your hand, Commissioner Sullivan.
I just want to, I'm a little frustrated, and Commissioner Tuma, I do appreciate how you go through these records, and I do deeply appreciate it, and I think it is important oftentimes to go a little slower because at the end of the day we can go faster. I do generally believe in that, but the flip of this is, and I'll just speak from my own frustration here, I was frustrated with this conversation. And what was frustrating about it is, you know, we're talking about feet and add this to that. And you know, that's, these are really complicated calculations and arithmetic to do on the fly. And these have real world impacts to the people who are on the ground. And when I came to this and I look at this and I'm like, we've got voluntary easements. We've gone through a process. And here we are kind of tinkering after the fact and pulling this out of the consent agenda, you know, and I do believe that, you know, it is important to get things right, but I also think, you know, we have these going through consent because we're trying to speed up this process. And we're trying to not reduce, you know, public input. We want public input, but we're also trying to expedite things, and that's why it's on consent. So I was a little frustrated with this conversation. I think it landed in a good spot. I think, you know, obviously the onus is on the applicant to put more information into the record. Commissioner Tuma, and I am grateful for you will go through everything. But I also just think we have to be mindful of the fact that, like, folks are out there and the applicant is out there working it every day, and I have to give them some grace that they are doing this.
And I will, and that's what I want to see in the record when I am given specific pieces of information that I have to rely on, and that's what I did. I went right to their record, what they filed, and I just wanted to truth test it. And had they put in there, Mr. Hansen said this to me, and here is his statement, okay, end of the game. It would have been all over. But what I was given, I had to walk it back. And I looked at what they said, and I walked it back, and it wasn't holding up. Yeah, are we talking feet and inches? Yeah, we are. But that's what just the confusion that I have. I want to know that Ms. Scholes is taken seriously. Like I said, if she was a crazy cat lady that lived in Minneapolis, I would not have made this an issue. But when I saw that it was Scholes that owned the property, and by the way, when you look at the initial filing that they gave to me, they didn't put that on the filing of your map. And that's the other thing that started setting me off. You go back and look in the record. When I saw it, it wasn't on there. We had to go find it, okay? So when I looked at whatever map I was given, I wasn't given that information. And so this is where the suspicion comes in, and I get bothered by it. And when I found out she lives a half mile from the church, I want to give her due credit because she's got turbines on her property. She's got 345 kVs that are going through her relative's property. In that situation, just like the landowners down there where we were doing didn't want the power line across in front of their driveway, or, you know, I want to give them due consideration so they were heard. I would have done this wholly different had she been here, and I probably wouldn't have been trying to speed it up if we tried not to get done quickly. But I just want you to know, I want the record to be good. I want it to be solid that I can look at it. That's what I was doing here. I wasn't just trying to show off. I don't need the feats. I was ready to put this in consent. That's where I was going. And I had 5 times that I got tripped up by information that was in the record that was not replete and complete. And so I agree with you. Absolutely. I want to go to consent as much as I can, and I will. And we can have conversations after the fact, but what I saw when I dug into this record caused me problems, and you heard most of what it is, and that's not all of it. So with that, I have a motion in front of us. All those in favor? Oh, wait, sorry.
Well, Commissioner Tuma, I appreciate your deep dive into the record and just want to reflect that I wanted to first reflect on that Big Bend, what this short transmission route is connecting to. It was referenced a little bit earlier, but this is a really important project for the state of Minnesota. And to push back a little bit on your real deep dive into the record, because the legislature passed a new law, there is some latitude for the commission to take longer than 6 months for just cause. But I just want to reflect both to you and to other commissioners that we don't get to play God on every single siting and routing docket that comes before us. And I'm not saying that you do.
Well, then don't say that.
Well, then you get to also listen to me go on a little bit about how I see things too, Commissioner Tuma.
I am listening, but
Our staff recommended that we approve this without an addendum. And so, sorry, I shouldn't have said perhaps that we get to play God on all of these dockets. I'm trying to reflect that we have an obligation by the state under the new law to do things faster. It's just the reality of the situation. You know that, I know that you appreciate that.
I'm not trying to slow this down, Commissioner.
Okay.
I am not. I'm trying to do the right thing, okay? That's all I'm trying to do.
Yeah, that's what we're all trying to do, Commissioner Tuma.
So
And I have a different
I agree with
perspective.
And I knew that. I knew what going into this, if this would come out the way I
Okay,
suspected it.
just make your motion and I'll vote for it. I just wanted to say to the public that all of these dockets are difficult for all of us sitting up here. Another reflection is that the applicant is doing their best to put forward what they need to get a route application and a siting permit done in 6 months to connect to a project that is very important for the overall reliability of the state's energy system. And we, sitting in these seats, have a great responsibility to look at those applications carefully, weigh the public interest in them, and then also have an obligation to make decisions within a much shorter time frame than we previously had. And so we have to give one another the latitude to say, yes, if you want to dive deep on a particular application, go ahead. But I want to reflect as the chair that I understand that there's also a law now that we have to do these things faster than we did previously.
And I appreciate the latitude that you gave me so that I could explain to the applicant and one of our best attorneys in this business things that I look for so that I can go to consent. That's what I was trying to do. I think Commissioner Hahn was correct, okay? That I'm going to look at these and I'll be careful, but I want to see information that I know landowners were taking care of. And the fact that they didn't talk to Ms. Scholes bothered me greatly, and it would have solved a lot of problems had I known Mr. Henderson did not want it. Problem solved. And now they know these things. They know that information needs to be carefully done. When a legitimate person comes up with an alternative, they should at least just sit down and talk to them. That's just good common, good graces, and they had 2 months to do that, okay? 2 months they could have talked to him. They didn't. So I agree with you 100%, so I don't know why this needs to be a disagreement. I agree. And
It's
I want
not
these
a
things to go-
disagreement.
I want these things to go fast. That is my desire. So, motion is in front of us. All those in favor of the motion signify by saying aye.
Aye.
Those opposed say nay. Motion passes unanimously. We are in recess till 12:30. It is. Okay, if you're here for the third item, start making your way up to the front where you come out of recess. Got all of our emotions worked out, so don't worry. It should go easier this afternoon. Right, Audrey? I thought so. So if you're here for item number 3, please make your way up or turn your cameras on, if you could, please. And Mr. Andringa, my understanding is, were you married on a Friday the 13th, or is your 15th anniversary? Was it tomorrow, or? Okay.
Tomorrow it is, yes.
We'll assume that it's a good luck Friday the 13th, but 15 years, 3, is it, or 4? I can't remember kids.
Say again?
How many kids?
Oh, 4.
4, that's what I thought. Congratulations on 15 years. And
Joy.
good job. Have a good time tomorrow. With that, now you get to formally introduce item number 3. Let us have it.
Thank you on that. Good afternoon, Chair Tuma and Commissioners. Third agenda item is docket number G-999/CI-21-135 in the matter of the Commission investigation into the impact of severe weather in February 2021 on impacted Minnesota natural gas utilities and customers. Docket number G008/M-21-138 in the matter of the petition of CenterPoint Energy Minnesota Gas for approval of a recovery process for cost impacts due to February extreme gas market conditions. Docket number G-004/M-21-235 in the matter of the petition by Great Plains Natural Gas Company for approval of rule variances to recover natural gas costs from February 2021. Docket number G-002/CI-21-610 in the matter of the petition of Xcel Energy to recover February 2021 natural gas costs. And finally, docket number G-011/CI-21-611 in the matter of the petition of Minnesota Energy Resources Corporation for approval of a recovery process for cost impacts due to February extreme gas market conditions. The questions before the Commission today are: do the gas utilities annual compliance filings comply with the February 2023 and June 2025 Commission's orders? Are Great Plains' conclusions of its voluntary conservation report reasonable? Are the gas utilities reports regarding interruptible customer compliance and incorporation of curtailment calls reasonable? Are the gas utilities reports regarding hedging, procurement, and customer communication strategies achieving reasonable savings for ratepayers? And should the gas utilities August 1st, 2025 annual compliance filings be accepted and approved? On March 10th, the Department filed an errata and clarification letter noting a recommendation to not pursue any new compliance filing reporting requirements for the gas utilities in this proceeding. Copies of that filing are in the front of the room for interested parties. Additionally, staff notes 2 corrections to the briefing which affect decision options. First on page 10 paper. In the 3rd paragraph, the last sentence of that paragraph should read, after a warmer than normal 2024 to 2025 season, which resulted in oversupply conditions, Great Plains determined that it would not increase base supply purchases beyond 80%. And the second correction on page 33 of the briefing paper in the 2nd paragraph, that should read Great Plains compliance filing, not CenterPoint. Otherwise, staff has no further comment, and the parties and staff are available for action. Thank you.
So we're going to handle it. This is not our first time around this block, so we're going to make it pretty simple. We'll go right to questions. No need for opening statements. And only if you're called upon do you need to state your name for the record, but you're all veterans, so the first time you're called upon, obviously state your name for the record and who you represent. And with that, we'll go to questions. Commissioner Hom.
Thank you, Chair Tuma. So I'll start with a little bit off from this topic, but I think this winter we had a pricing event. So I think a lot of ratepayers are more interested in that one than this one. So I'll start with the question on that one. So when this pricing event will be reflected in the customer bill this year, that Winter Storm Fern pricing event at the end of the January, we had that pricing event. Will it be reflected in the February, March bill, or it'll be a more long run reflection in the customer bill? So let's start with the center point.
Center Point.
Thank you, Commissioners, Commissioner Hom. Jason Luce, CenterPoint Energy, and we have set the merit on the phone here as well, and I'll let him answer that one as far as the billing question.
Mr. Demerit.
Yes, set the merit on behalf of CenterPoint Energy. Commissioner Hom, Chair Tuma, I think our intent would be to not reflect the Fern weather event on the February bills, but instead roll it through our annual AAA filing. So you would see it going into effect after we make our annual adjustment filing September 1st, and we would collect those costs from September 1, 2026 through August 31st, 2027.
So in other words, it'll be part of your true up rather than reflecting in the real time in this case.
Mr. Demerit.
Commissioner Hom, that is correct.
Thank you. And the next, Xcel.
Steinhauser.
Good afternoon, Lauren Steinhauser on behalf of Xcel Energy. Chair Tuma, Commissioner Hom. I don't have the exact answer, and I don't have anyone online who can answer it for me, but I would expect that it is similar to CenterPoint, that we would wait to the AAA. I can confirm that after the hearing, or try and get the answer now, but I don't have it at this moment.
Commissioner Hom.
Yeah, I think I understand it's unfair. You said a little bit off this one, but I think personally also I had a serious concern about the upcoming bill, and I think ratepayers has a lot of concern with higher bill because media already covered that issue in many different places. So I hope that ratepayers are understanding and getting this information clearly. So that's why I'm asking. So if you don't have that answer now, I think we can wait for, you can find the right answer rather than we are guessing it. So I think that's okay.
Who next, Mr. Hom?
Mark.
Merck. Who do we got for Merck?
Good afternoon. Joylyn Huffman-Malik on behalf of Minnesota Energy Resources Corporation. Commissioner Hom, Chair Tuma, we agree with CenterPoint. The extraordinary costs that occurred due to Winter Storm Fern that we spoke to in our 3-day or 14-day reports, those would be recovered through the annual true-up for the 2025-2026 reporting year.
Thank you. And then Great Plains?
That leaves us Great Plains. Who wants to speak for them?
Good afternoon, Commissioners. Brad Davison, Great Plains Natural Gas. Just to echo what everyone else has said, ours would also flow through the AAA filings for the annual in the annual deferral. So.
Okay, thank you. So yeah, I don't know how to explain to public and the citizens of Minnesota, because we had a lot of news media covering that issue, and there was a lot of concern going on. And then plus potentially natural gas price, commodity price can go up upcoming month. So yeah, I think somehow we have to properly communicate this issue with the people so they can prepare to deal with this potential hike in the natural gas price. So sometimes general public doesn't understand this lack of how you pay this event, and that can make people be very curious about when they're consuming less, sometimes they're paying more, and then that creates this, that's a great moment for the people that, oh, maybe conservation is not a good thing. So I hope that we have a proper way to communicate with the people on this issue, because the media covered this one so much. So I'll ask the department for the next.
Sure, Ms. Campbell.
So we heard that it'll be reflected in AAA, and do you have any concern waiting for that long, or do you know the magnitude that we can reflect this change in single year recovery? I'm sure it's better than Winter Storm Uri, but I think what we heard was it was bad this year too.
Nancy Campbell for the department. I think my understanding on average was that the impact was looking like it was going to be about $30 for the average residential customer in their next bill for this event. So not too significant. And obviously, if we spread that over a one-year period, we're talking about closer to less than $3 right, a month. So.
Okay, thank you. Yeah. I'm glad that it's a lot less than I was worried about, but I think still it can be an impact to the bill. So hopefully we can have a good communication with the customers on that issue. So I'm done with this question unless the commissioner has a follow-up.
Mr. Hom, still,
Okay.
still yours.
Thank you. So relate to this issue and then winter community reporting requirements. What have you learned from these ongoing dockets that helps you to deal with this winter storm Fern? Because I think one of the reasons we keep doing this one is to try to learn from winter storm Uri event to improve upcoming issue. So we had another pricing event this year. What was useful and helpful for you to deal with the winter storm Fern through this process? So start with the Centerpoint.
Chair Tuma, Commissioner Hom, thank you. Just at a super high level, Centerpoint was in a much different situation for Fern. Our base load was much higher. We had the ability to use much more storage, which we did. Just timing the event, we were prepared for it, and we had a meeting at 7 a.m. every day, I think, and went through with our gas supply team, and they did an incredible job. I think it's reflected in our filing. Our exposure was pretty minimal to the spot market during that event. So, I mean, comparing it to Uri, it was much smaller.
Yeah, I understand that the magnitude was smaller, but from this winter storm Uri event and then ongoing this commission investigation dockets, so have you changed any practice that helps you to deal with the winter storm Fern? That was a question I'm trying to ask.
Thank you, Chair, Commissioner Hom. From my perspective, I wasn't here during Uri, so but I will say that on the regulatory side, we are more involved in the meetings with the gas supply team. Obviously, since Uri, Centerpoint has increased storage quite a bit. We've increased just our overall mix of where we're getting gas from, so it's given us more options. We've utilized peak shaving a bit more in this latest event as well. So I'm not sure if so Paula and Crystal are two experts on this, and they're both out of town. One of them may have joined, so if Crystal's on the line, she could probably go into a bit more detail on that.
Crystal, are you there? I'm not hearing anything. Do you see anything?
No, I don't see her on there either. Like I said, they were both out of town this week, so.
Commissioner Hom.
So yeah, then I can move on to the Xcel.
Steinhauer.
Chair Tuma, Commissioner Hom, Justin Holstein is online for Xcel Energy, and he has the specifics for you.
Mr. Holstein.
Chair Tuma, Commissioner Hom, thanks for the question. Since Uri,
You need to state your name for the record, but that's okay.
Oh, sorry. Justin Holstein for Xcel.
That's okay. Thanks.
All right. Apologies. So since Uri, we've deployed all of the strategies that we discussed in our annual compliance filing. So we've increased base load over what it was in Uri. During Fern, we deployed our peak shaving facilities to sort of shave down some of the highest prices. We utilize all of our geographic diversity to try to avoid purchasing at the highest price locations on any given day. Issued curtailments for the entirety of the event and asked customers to conserve. So overall, not only was the impact less, but I think we bought less. We were less exposed to the daily spot market during those critical times.
Okay, thank you. And then Mark. Yep.
Mark.
Good afternoon. Josh Fieber with Merck, manager of gas supply. Not unlike what Justin went over, we were able to implement a lot of the strategies that we've learned since Winter Storm Uri with increased base load, some more front-of-month priced supply. So we had some minor purchases as a result of that and maximizing our storage. One thing that I guess Merck was able to implement for the first time was economic curtailments because of the price for those customers that were subject to those price increases there. So we were able to minimize some of our gas purchases as a result of that, and the overall communication and implementation of that went really well.
Okay, thank you. And Great Plains?
Great Plains.
Yes, Brad Davison, Great Plains Natural Gas. I would say that since Winter Storm Uri, we've implemented, all of those things from that event that has kind of helped mitigate some of these events that we've seen. So, like everyone else has kind of been saying, since Winter Storm Uri, we've increased our base load and really used max storage capacity and really used it in a way, really saving it for those high risk events to kind of reduce our exposure from the spot market.
Okay, thank you. And then department, I'll have a different question for the department. You heard all this discussion, and then department didn't make any recommendation of additional improvement on this ongoing investigation and compliance filing. Given that, I'm not suggesting any decision today, I'm not suggesting anything, but have you thought about implementing some of these suggestions into the existing ongoing annual or monthly, such as PGA, AAA, demand entitlement, rather than doing these separate CI dockets? Or do you prefer still keeping in CI dockets so every utility has a little more attention to this issue?
Ms. Campbell.
Overall, I'll just say that I think this process has worked really well in this docket. I think it is really good focus to make sure that the utilities are doing all that stuff, all these things. I think we've definitely seen an increase in baseload purchases and first of the month purchases. We knew peaking plants weren't always available during Storm Uri, and they seem to be doing better about that. We're seeing increases in storage. People are doing conservation calls. Some of the gas utilities have changed their tariffs so that they can do economic calls. So I do think that focusing in this docket has really helped, and we've seen improvements on that. If you're a visual person, I really liked Table 5 on page 25 of the briefing papers to show the changes that, for example, CenterPoint has made since 2021 to 2025. John Kundert for my staff did that table, and I really think it really shows all the changes that all of the gas utilities are making, but in this one it's for CenterPoint. And so that we're more ready. I mean, I think it's really important. We could do it in the AAA, but I feel like there's better attention on here. Maybe we don't have to spend quite as much time, but, we just saw Storm Fern, and, we might see other future events. So I like it. I'd be open to rolling it into AAA if that's what you really feel, but I feel like this has brought the right attention to make sure that people are ready. The gas utilities are ready.
Mr. Hahn.
Thank you, Chair Tuma. Yeah, but also I think it has a strong relationship with your workload. That's why I want to make sure that if you're comfortable doing it, say, independent dockets, and then your workload is manageable, that's great. But I think if you had a concern with the workload, we can move this into the individual dockets. So I think we don't need to have a multiple docket dealing with the same issue. So if you're comfortable, you think it's valuable, we should keep it as it is. I'm not suggesting anything. That's why I start with the statement saying that I'm not suggesting anything. I'm just asking you.
Ms. Campbell.
I'll just say, if for the next filing, we'll take a look at that to see if it makes sense to fold it in, or if we think the continued separation. And plus, we'll see an event, Storm Fern, in the next compliance too. So.
Yeah, that was my guess too, because of Winter Storm Fern, there's no way we can do away with this one anyway, anytime. And also, as you said, we are getting this 1 in 100-year event every few years. So I think we have to carefully manage this one. But also I have a fully recognize your workload issue at the department and our staff too. So I think we have to deal with it as an ongoing basis. Thank you for your answer. So one more question, unless the commissioner. Thank
absolutely.
you. So the Great Plains. So I saw that you agree to consider that economic curtailment. I think decision option number 5, right?
Great Plains.
Yes, Brad Davison, Great Plains Natural Gas. Yes, decision option 5, we did agree to look into the conservation methods a little bit more detail, so we are supportive of that.
Yeah, do you understand? I don't think a department is asking you to reduce demand entitlement or using this as a peak shaver per reliability. It is more economic curtailment. So when you have to buy more spot market or monthly the contract, this is a one way to mitigate price spike. I think that's department suggestion, but I saw some of your discussions saying that, oh, you had a concern with the reliability issue. I don't think a department is recommending this for the reliability tool. I think a department recommendation and also other utility saying that they are using some economic curtailment to manage the price, not the reliability.
Mr. Davison.
Yeah, I would agree with that, and I think that is we will definitely look into that to see if we can incorporate it to help with these high price events if it would make a difference. So.
Yeah, so probably not only the pricing event per se in that magnitude, but if there is any potential significant impact, the economic tool will help company and ratepayers, because if your ratepayers are happy, company will be happy. So I'm pretty sure that you have a more opportunity than pricing event to exercise that economic curtailment, which is voluntary basis. No, you are not forcing anybody. You are telling people conserve. That will help their bill. If they're happy, I'm sure everybody's happy if you're a customer. And then I don't know whether you guys are decoupling, so that's why I am hedging my judgment on this. So if you need any throughput incentive, I think that's potentially concerned. But if you don't have a throughput incentive because you don't have a decoupling, but I think probably you may want to think carefully about this to making sure that any conservation is a great tool to help everybody.
Mr. Davison.
Yes, understood.
Okay. With that, I can make a motion, unless the commission
No
has
questions. Doesn't look like there are any other questions. So, Commissioner Hom, give us a motion.
Thank you, Chair Tuma. So I'll make a motion, decision option 1 through 5.
See no further discussion. All those in favor of the motion signify by saying aye.
Aye. Aye.
Those opposed, same sign. Motion passes unanimously. Okay, let's transition now to item 4, 08-133, the SIP docket. And if you're on that docket, start making your way up, and we'll take a little time to get transitioned. If you're on that docket and you're online, please turn your cameras on. As you're making your way up here, just a forewarning, Miss Ricker has not been feeling well. Sorry about that, but she is valiantly staying in the game, but virtually. So she's not. Well, we might need a minute here too. You want to take a?
Well, I don't have a copy of my filed draft motion. Do we?
That's not good.
I think we have hard copies.
We're going to take 5 minutes to make sure staff have, because that was going to be my next question, that you have all the motions. So let's take 5 minutes, but everybody keep coming up and keep turning your cameras on for the SIP docket. There should have been a package that I will wait till Isabel turns her camera on, because that will be critical. And then we'll get going. There is Miss Richter. I tell you, on time. Okay, here's the plan. We're not going to do formal full opening statements, okay? But we do want to hear from parties, kind of give us your thoughts on all the changes and Commissioner Partridge's decision options. So we're going to want 1 or 2 minutes of just general ideas on where you're at this stage with everything that's been late filed, and maybe a quick, where should we be focusing today? So again, really quick, 1 to 2 minutes on that. My thinking was to let Commissioner Partridge kind of walk through her rationale first. I think that will tee things up well for the process. As indicated earlier, Ms. Ricker is not here, but she's been preparing everything, and so she wanted to participate. Thank you for soldiering on, Ms. Richter. We appreciate that. So we'll get started by you doing the docket introduction, formal introduction, any statements that you want to make, and then we'll go to Commissioner Partridge to kind of lay out her proposed decision options. So everybody knows what we're working from, though. It should be titled Corrected Preferred Decision Options. And then we also have the compiled decision options if there's something you want to pull in from that and drop into the decision options. But when our order writer is putting things together, we'll be off of the corrected Partridge and entering and modifying that as we go through the process once we get kind of through the questions and answers stage. So with that, Mrs. Richter, formally introduce the docket and state anything you need to state from there, and then we'll go to Commissioner Partridge.
Thank you, Chair Tuma, and let me know if you have any issues with my audio. Thanks for accommodating me being virtual.
We can see you well. So.
Great. Excellent. Yes. Note to others, don't go to preschool birthday parties the week before an agenda meeting. You'll get the flu. So item number 4 is docket number EG999/CI08133 in the matter of Commission review of utility performance incentives for energy conservation. The issue before the Commission is should the Commission approve, modify, or deny the proposed modifications to the existing shared savings demand-side management financial incentive mechanism or implementation beginning in 2027, as proposed by the Department, Center for Energy and Environment, and Fresh Energy. There have been a number of filings since briefing papers were filed. The Commission received updated preferred decision options and a small number of modifications from CenterPoint Energy, Minnesota Energy Resources Corporation, Minnesota Power, Otter Tail Power, Xcel Energy, and Center for Energy and Environment. As you noted, Commissioner Partridge also filed a list of preferred decision options, and folks should use the corrected version that was filed yesterday. All of the modifications, including Commissioner Partridge's, are included in the staff compiled decision options that were filed yesterday, with the exception of CEE's modified decision option 19B, which also came in yesterday. So hopefully now commissioners have hard copies of everything they need, and there should be hard copies of those 3 main filings on the side table in the large hearing room for anyone else. Let me know if you need anything else, but I have nothing further. I'm available for questions. Thank you.
Thank you, Ms. Richter. Commissioner Partridge.
Thank you, Chair Tuma. Hi, everyone. I want to just start off by thanking Ms. Ricker for all of your fantastic work, and I'm so sorry you can't be here to bask in the glory of it, but these were fantastic briefing papers on a very complex topic, and I felt like these were so clear and easy to understand, so thank you so much for that. I also want to thank the joint petitioners for bringing forward this new idea on how we can better target specific goals of our energy conservation and optimization program and encourage utilities to really excel in specific areas that are most important for our state and for customers. So thank you for bringing that forward. To bloviate a bit, because That's what we do. I do want to say that the Conservation Improvement Program, as it was previously known, and now the Energy Conservation Optimization, or ECO Act, has been extremely successful in providing benefits to our state. It has lowered customers' bills who participate in the programs. It has lowered rates and bills for those who don't participate in the program. It has prevented us from investing in all kinds of supply-side investments that would raise rates. It has provided local jobs and economic opportunities all across the state, and it has helped to reduce emissions and pollution. And so that is why we provide this incentive. It is to encourage utilities to save energy, which they would otherwise have a disincentive to do, and it has helped to put energy efficiency as a cost-effective resource in a competitive playing field with supply-side resources that the utilities get to earn an investment on. That is why we do this. And so it may seem silly that we're providing an incentive for utilities. We don't usually talk about that. We talk about earnings, but that's why we do it for those who are listening and this is new to you. I filed a draft motion because this was such a complex topic and there were so many different decision options. I want to just let my fellow commissioners know that my mind is not made up. I just wanted us to have a starting point that was, I think, comprehensive so that we could start plugging in, plugging out what we ultimately decide upon. And I also, let's see, where was I? I had a few things I wanted to mention here. Oh, I do want to frame up what the motion I think is intended to do, and then I hope that the parties will let me know if it is doing the thing I have thought that it is doing, because it was very complicated even with the wonderful briefing papers. So my intent was to largely take the joint petitioner's proposal as it stands last, minus the late filed 19B, which I actually think is fine, but this was before that, to take that last petitioner's petition, put that into a proposal, and then I made just a few adjustments, and these are the adjustments I meant to make. One was an adjustment to the low income incentive for both the gas and the electric side. This came out of some comments filed by Minnesota Power and others, and it essentially says that we could provide a lower incentive at lower levels of achievement for the low income spending goal, and then a higher incentive that sort of escalates more quickly for those higher levels of achievement. That required an adjustment to the overall net benefits cap, so that is also reflected in here. And then the only other adjustments I intended to make were on the very final section of the briefing papers. Those decision options, I tried to just kind of streamline and clean up a bit. I wanted to reflect that the commission does not have the authority to approve the inputs and assumptions of the cost effectiveness test beyond what is used for the financial incentive. So I put in some clarifying language. I do have thoughts and opinions on the inputs and assumptions of the cost effectiveness tests that kind of popped up within the record that I do want to talk to. But we don't have authority over that, so I wanted to clean that section up. And then, frankly, I just wasn't clear on what number 48 was trying to do, so I did my best to interpret it and reflect that back. But I am very interested to learn what you all think, if I nailed it in my intent, and then where you think my intent has gone wrong. So.
Thank you, Commissioner Partridge. That's very, very helpful. It did really help focus us in on how to put things together. I think it really was a comprehensive readjustment. It needed a comprehensive plan. Otherwise, you move one needle and it affects everything else down the road. So you need to have a starting place. Here's my plan for the opening statements. I got joint commenters first. I got Centerpoint second. I got Merck third. Great Plains fourth. Xcel fifth. Otter Tail sixth. And last but not least, our folks from Minnesota Power up in Duluth. And it sounds like you're going to get a nice, good snowstorm here in a few days, so it's probably good that you stayed in Duluth. And so, starting with Dr. Lieb for the joint commenters. I think you're speaking for them. Is that correct?
Yes. Chair Tuma, thank you.
Introduce yourself for the record.
I'm Sydney Lieb. I'm the Assistant Commissioner of Regulatory Analysis at the department. We first want to thank CEE and Fresh Energy for working together collaboratively with the department on this. It's a pretty wide-ranging and at times weedy issue, and I think we are all really excited about what we were able to put forward here collaboratively. And we also thank the utilities for their input on the process and for sort of on various cases or on various issues helping us to center and find the art of the possible. I'd secondly like to also echo some praise for Isabel and the staff. I also agree that the briefing papers were really well organized, really excellent, and I, as somebody who sort of lives docket to docket or week to week and docket to docket, also appreciate when those are done in a really detailed and organized way. So I think they were excellent. And then lastly, we thank Commissioner Partridge for her leadership here. We are completely in alignment with her decision options. We appreciate the clarifications, and we have no changes to the draft motion.
And I'm assuming CE, Fresh Energy, nothing to add. I think we're going to talk on 19 when we get into questions, but nothing more to add. Then we got next, CenterPoint.
Good afternoon, Ethan Warner with CenterPoint Energy. Chair Tuma, Commissioners. CenterPoint Energy was originally, well, first actually I should say, echo all the thanks for Isabel and sort of streamlining a very complex set of issues into some very concrete decision options. So much appreciated with working with everybody on getting that squared away for this hearing today. Also, thanks to the joint commenters. Even though we have some disagreements, I do appreciate the discussions that have gone on over the last 9 months or so and trying to find compromise where we can going into the hearing today. CenterPoint Energy was originally neutral on the multi-factor mechanism. We supported the goals of the joint commenters proposal as well as the factor selected. Our main concern at that time was just really about the calibration of the insulation and air sealing metric. Our concerns with the calibration of the mechanism just increased over time with the technical reference manual results, as well as at least what we know of the cost effectiveness framework for ECO in the next triennial as of today. Obviously that is not finalized, and we're not looking for necessarily a decision on that in this particular context. But historically, the financial incentive mechanism has at least considered, if not outright, been calibrated with the cost effectiveness framework. And so that is one of the reasons why when we ran the numbers, we ended up asking for a mechanism that was calibrated to what we know of the cost effectiveness framework and the resulting net benefits to our programs. And that came out to something higher than 6% net benefits, but then we scaled it back to 6% based on things that Center for Energy and Environment pointed out, in which we're going to recover some of those savings through, things like, identifying the baseline efficiency of new furnaces that are rebated, for example. The other decision options that we supported with Merck allow for flexibility of our performance among the factors and sort of addressing our original concern back when this docket first started and we first issued comments. Those concerns have not gone away, but they are, I would say, secondary to our main concern, which is the calibration of the mechanism around the cost effectiveness framework and avoided gas commodity costs going into the next triennial. I'll leave it at that.
Ms. Stasny, I think you're next.
Thank you, Chair Tuma and Commissioners. Kristen Stasny on behalf of Minnesota Energy Resources Corporation. I would echo the thanks that others have already provided to Commission staff regarding preparation of briefing papers, and to Commissioner Partridge for the preparation of the decision option outline, which was very helpful in getting organized. We also really appreciate the work of joint commenters in taking into consideration the views of the utilities, in particular for Minnesota Energy Resources, on the insulation and air sealing metric, ensuring that that would be an achievable metric for Minnesota Energy Resources in light of some unique considerations for Merck in the dispersed service area. I would just note a couple of items of difference between the Partridge set of decision options and what Merck had filed as its preferred decision options, echoing a lot of what CenterPoint just stated. The first is the increase to the calibration for the overall net benefits cap. We agree with some of the concerns that were flagged in CenterPoint's last filing regarding impacts that are undermining the incentive, both from the TRM, which were addressed in Joint Commenter's revised proposal, but also in the cost effectiveness framework, which is currently under consideration in a separate docket. So those are expected to reduce the overall net benefits, which by reducing the overall bucket of net benefits, it will reduce the overall incentive. And so that will have impacts eroding the incentive. And so the intent of moving from the 5.6% overall cap to the 6% overall cap was just to recoup some of that erosion, not to put the gas utilities better off. I don't think that we're trying to grow the incentive. I think what we're really trying to do is maintain it at that same level that joint commenters had recommended. And as they recognize and as reflected in briefing papers, that still is going to be likely a reduction to the gas utilities overall incentive, just as a result of a lot of different factors, the TRM baseline change, and just the reality that, you know, for eco programming, a lot of the low-hanging fruit has now been fully captured, and so we are looking at more expensive measures to capture continued savings from customers. The second one, which I won't go into too much detail on, is flexibility and whether or not the cap should apply to each of the individual 3 metrics or be applied on sort of a universal basis. Our recommendation was to allow for that additional flexibility. Under the proposal, we would still have to meet the minimum for both first-year savings and low-income investment. So it would ensure that we're continuing to prioritize all 3, just provide more flexibility. And then the final recommendation, Merck had originally proposed to expand insulation and air sealing to include EFS measures as well. We have dropped that. There wasn't a lot of support, so we have moved off of that. Obviously, EFS is important, and so I think incentivizing that is something that we continue to believe is important, but it is captured in first-year savings. We do, however, continue to support CenterPoint's recommendation that insulation and air sealing include high efficiency windows, which is a relatively new measure that gas utilities are beginning to adopt, and we've seen a lot of success. And that basically is an insulation measure, insulation in windows. So it really is largely consistent with the insulation and air sealing metric that is being proposed here. It would just capture one additional measure. The savings that's achieved by those high efficiency windows is relatively small, so it's not going to be an enormous impact in terms of increasing the achievable savings, but we just think that it's consistent with this concept of capturing insulation. And with that, I apologize. I went way too long. I'm available for questions.
I think they gave you enough time. We have Great Plains next. Oh, there you go. Mr. Davis.
Good afternoon, Commissioners. Brad Davis from Great Plains Natural Gas. So Great Plains does support the joint commentator proposal and appreciates their time and effort on this. Really, the one comment that we had was related to the proposal for the insulation, the recommendation for the changes for the proposed for the insulation and air sealing first-year energy savings to use the utility-specific program potential values to set the threshold and goal rather than the utility-wide metric. Outside of that, we really didn't have any other comments. As a small kind of rural utility, these changes don't maybe impact us as much as some of the other bigger utilities. You know, a large part of our incentive is really driven around the custom program. So that was really the main reason for our limited comments.
Thank you. Next, Xcel.
Thank you, Chair Tuma. Nick Mark with Xcel Energy. I guess I'll echo the thanks that have been expressed already to the Commission, the appreciation for the briefing papers as well. And especially, I think, to the joint commenters for being innovative and also flexible and not having pride of ownership in the ideas. They've really been willing to incorporate suggestions along the way, and that's been very much appreciated from our side. I also want to thank, in particular, joint commenters and the commission for just being where we are in this process now at this point in time. I've been working in energy efficiency in Minnesota for almost 20 years. This is the first time that we're going to know what the financial incentive mechanism looks like before we file our triennial plans. That's hugely important. It actually gives us an opportunity to make meaningful strategy decisions around, what are the ways that we can most drive net benefits? How can we do the most good for our customers and for our shareholders simultaneously, and really respond to the policy signals that the mechanism is trying to give us? So I think that shouldn't go overlooked or underappreciated. I appreciated hearing Commissioner Partridge's rationale. That was exactly sort of what I took away from the changes you were making, both on the low income component as well as sort of the cleanup on some of those later pieces. Some of those go back quite a ways. Some of them aren't really even relevant anymore, but I won't get into a history lesson on all of that. So I think we would be entirely happy with the decision options that Commissioner Partridge put forward. I do think that if the commission is interested in considering on the gas side something to reflect the concerns around declining avoided costs, I think there are some relatively easy changes to make that don't involve rewriting all of the decision options to implement. And so we can get into that if that's of interest. But I do think it's at least worth considering. There was a very positive and helpful response among parties when Xcel brought forward sort of what we see for avoided costs on the electric side. And I think it's only fair to have consideration for the trends in avoided costs on the gas side. So with that, I'm happy to address any questions.
Thanks. I thought about it. I love history. And this would be a very thick history book, but there's probably only about 30 people in Minnesota that would read it and understand how to read it. It took me a while to get my brain back around just the SIP concept. So there's a lot of history here, but it's quite interesting. I think next, Mr. Grenier from Otter Tail.
Thank you, Chair Tuma and commissioners. I just want to echo again a lot of the comments that have been said here this afternoon. Commissioner Partridge, the comments that you recognizing the joint petitioners and the effort that they went through, and I would say a lot of that work led by CEE. Really appreciate that. There was a time, and thinking about the history here, and I've been around long enough to remember that there wasn't a lot of collaboration, and I think CEE really created a collaborative environment where everyone had a voice. And like Xcel said, they would listen. And I think that's so important, because many times we would come into this room for this docket and we'd be miles apart. And I think there is quite a bit of alignment here today, at least on the structure. Maybe there's some number of things moving around on the electric side, but I think we're pretty much in alignment for the most part. So we have made a lot of progress over the years, and that's important and reflects all the effort that all stakeholders have put into it. So where Otter Tail is we do recommend Commissioner Partridge's preferred decision options. We do recognize that there's some give and take with that, but we do think that it's balanced and it lands in a good spot. And those decision options.
Last but not least, who from Minnesota Power is going to share their thoughts? Dr.
Chair Tuma, commissioners, can you hear me?
We can hear you loud and clear.
Wonderful. I'm Jennifer Kuklinski on behalf of Minnesota Power, and apologize that we aren't able to be with you in the room today, but I too want to echo the thanks to staff and Isabel's work for the thorough briefing papers, and also Commissioner Partridge, the work of Commissioner Partridge to put kind of the package of decision options together for us to work from today. I would also just want to note the appreciation that Minnesota Power has for the joint commenters and the collaborative approach, as others have discussed, and their willingness to incorporate recommendations from utilities, which I think helped to get us to the decision today ahead of the triennial filing, as Xcel had noted. when MP made our proposal in the record, we were looking at each component individually and not necessarily as a package. So in areas where Minnesota Power's position may seem unclear, or when Minnesota Power may have seemed to change its support for a given decision option compared to what we may have seemed to have supported in the record, this is primarily due to the way that we approached our evaluation and analysis when developing our recommendations and comments. And so with that being said, MP's intent through this entire proceeding was to maintain similar levels of financial incentives for similar levels of performance, while giving utilities a little more incentive to earn more at higher levels of achievement, kind of recognizing where we are in our energy transition. And so overall, MP's concerns have been alleviated by the updated package of decision options filed by Commissioner Partridge. And I'll just note that MP is also supportive of the modified decision option 19 filed by CEE. I, along with my colleague Lisa Beckner, who is online as well, are available for questions.
Excellent. Commissioner Partridge, you want to start with questions?
I would love to. Although I have to say there's a lot of agreement, so that's a win.
Maybe not go.
Here we go.
Don't mess it up.
I'll have my motion right now. So I want to talk about the, as I've said, we don't get to approve avoided costs, that assumptions and inputs that go into the cost effectiveness test. However, those assumptions are so important for our work, not just your work in ECO. They matter in terms of how much efficiency you go out and procure and achieve, and that matters for your IRPs, for your rate cases, for resource acquisition. It matters to this commission. This is far and away one of the energy resources that I feel should have the most support across the state from everyone, because this is the resource that makes sense. I really struggled reading what the trends are looking like for avoided costs in the cost effectiveness tests. It is not just the cost of gas, which was jaw-dropping. It is the avoided cost of energy on the electric side. It is the avoided capacity costs on the electric side. All across the board, these things are coming down, and I did pull the numbers. So let's start with gas, since that one is something that's come up a couple times in opening remarks. For CenterPoint, it looks like a 26% reduction compared to 2024 to 2026. For Xcel Energy, for avoided energy costs on their electric side, a 26% drop. For Xcel Energy on the avoided capacity, or maybe this was a general number, I can't recall, 22% decrease from the previous triennial. I feel like I'm living in an alternate reality. I have seen no headlines about lower energy costs in the last few years here. In fact, all we hear is about how energy costs are going up. And I'm not just relying on headlines. The MISO auction for capacity for the summer for 25 or 26? I'm looking at my MISO people. Was 22 times higher than the year prior. That's 2,200%. How are we seeing a 22% decrease in avoided capacity costs? And this matters. Like, this flows through to the rate cases that you guys appear and advocate for the consumers on. Like, I'm just so confused that I don't know, and frankly upset. As you can see, I'm shaking. Like, this is really, really awful. I've pulled some data, and I'm hoping that you'll continue to consider this. One of the positives here is that these are not set in stone. All of the things I'm referring to are in a proposed decision. But I want to just say that just because your methodology is consistent from one cycle to the next does not mean that it remains valid. You know, you have to look at the outcome and does that reflect the reality we're living in? And frankly, that does not reflect my reality. So I don't want to make a decision here to recalibrate the financial incentive because these inputs are so shockingly low and going in the opposite direction of all the data I've seen. I want to trust that the department is going to really take a hard look at this and make a good decision on these. Because I know that when you come to us and advocate on behalf of ratepayers across the state, you want them to have lower bills. You want to reduce our investments in capital on the gas and the electric side if they are unnecessary. So I don't know that I have a question, but I would like a response because I know that Mr. Fryer's staff works very hard and they are crunching the numbers. And I think that this really is a misalignment of the time periods that are being captured, increased volatility in our markets, you know, very recent changes in capacity costs on both sides. I mean, I can't remember how many interstate gas pipelines are in a rate case right now requesting, was it Northern Natural that requested 100% increase in their rates? I mean, on all sides, whether it's gas, electric, capacity, energy, I just really struggle to understand why we're here talking about lower avoided costs in our energy efficiency tests.
Commissioner Sullivan and Commissioner Hom wants to piggyback right off of those thoughts. So let's do that before we get a response from.
I'm not coming in off of the ropes because you just did that. But it's a wrestling analogy. But, geez, I thought I'd get a laugh. But what I just want to augment the point that you made there. And what I am concerned about, and when you mentioned MISO, at the last MISO meeting, the last full MISO board meeting, the price of natural gas in MISO, the price of natural gas has increased by 54% in the last year, and that's led to a 46% increase in the wholesale electric prices in the last year. So that's the wholesale price of electricity on the MISO system. And there's no projection, certainly within MISO, the projection is not that that's going to go down. In fact, it's going to go up. And if you look at all the drivers, I think as you perfectly pointed out, like there's no headline out there that shows affordability is not a problem. And just to add to what you said, like my concern is that, and especially in here where we have the natural gas number being as low as it is that when Minnesotans are going to, and I view the ECO program as the state's mainline affordability program. Like there's nothing else that's close. Like this is a program that is built for, if I could rename it, I would rename it the affordability program because that's what it does. It reduces people's bills. And when I fear prices are going up on the system, that our mainline affordability program is not actually going to reflect that reality. And I think that's the point that you're raising, which I think is critical, is that we're going to see potentially rebates going down when the price of gas, which is the marginal fuel, and at least on the electric side, and it'll be reflected in people's bills on the gas side. We're going to see the prices going up, and we're going to see our ability to address them through the ECO program going down. And that I just want to add to what you just said, which is like that's a problem. Like that's the fundamental problem.
Mr. Hom, we're on a tag team here. Keep the wrestling analogies going.
Thank you, Chair Tuma. I have a question to Xcel Energy Resource Plan.
Okay. I didn't know if Mr. Partridge, did you want a response from the department first, or did you?
Let's go with this one.
Okay.
This is more specific.
Okay, so I'm new to this ECO because I'm only used to SIP program prior to 2010, which is very archaic. So I need a little more education from Xcel Energy, how they are doing resource plan. So when you have approved eco program, so certain energy efficiency program. How do you put that in your resource plan process?
Mr. Mark.
Thank you, Chair Tuma. Commissioner Hom, I'm going to preface this by saying I'm new to the electric side, relatively speaking, and I haven't been involved in an IRP, so I can speak only at the highest of levels. If we want to get into more detail, I think I've got some support behind me who can come up, but
he's ready.
I know he's there.
But at a high level, eco, you can kind of think of eco as the means by which we go out and acquire the energy savings that the resource plan calls for. So as I understand in the resource planning process, we put together various bundles of energy efficiency at various levels of achievement and various cost of that achievement, and then allow the modeling process to identify which is the optimum level of investment in energy efficiency, given the anticipated costs and how much is available and what the system needs at different times of day and times of year. So that sort of identifies, here's how much energy efficiency you need, just as it would identify, here's how many solar farms or wind farms you might need. And then for energy efficiency, we go out and acquire that resource by implementing the programs that are described in the triennial, just as, if we were building a new generation facility, you'd solicit bids and try to obtain it that way.
So after you have approval in the triennial eco, certain programs, you put that into your ILP as a potential option, and then your ILP is going to pick it up based on the so-called Minnesota test or cost-effective test you got approved by department, right? So do you have your own cost effectiveness of energy efficiency program in your ILP? That was my angle of the question.
Mr. Mark.
I believe, and subject to correction here, that the primary consideration in the IRP is the cost of the energy efficiency. So less focus on some of the other components of cost-benefit analysis that are brought into, especially the Minnesota test, and really a focus on what does it cost us, the utility, to implement these programs and obtain that level of energy savings.
Yeah, that disconnection gives me a lot of trouble. Maybe it's my misunderstanding, but if certain energy efficiency is cost-effective in Minnesota test, why can't Xcel Energy ILP pick it up? Rather than you run it as an option, why don't you put it as a baseline assumption? Because it's very cost-effective.
I don't know if I'm going to help, but I think the way that they put it in is they back it in. They basically say 1.5% or 1.75%, and then they subtract that. And they view it as a compliance, not that they're intentionally dismissing it, but it's viewed as a compliance resource. I don't think they look at how economic it is. Sorry, our Commissioner.
Commissioner Partridge.
Here comes.
I have a suggestion that Mr. Schlanta explain.
I'm Carl Schlanta on behalf of Xcel Energy. So Commissioner Sullivan, Commissioner Hom, for the way that it fits into the IRP, right, we do create those bundles that are based on our eco plan, and then we back out any energy efficiency that is included in our load forecast, and then bid in the energy efficiency as a resource, so it does compete against the other resources that we are able to select, so wind and solar and other resources there. And in the IRP, we're looking for the kind of the optimize PVSC, the present value of societal cost there. So it does take into account some of those externalities and such as well that the Minnesota test does. So it is fairly similar. So we look at that IRP, we run through that based on our most recent eco plan. And then in eco, when we're looking at the cost effectiveness there, we will take the output from our IRP and use the marginal costs that come from our most recent filed approved IRP and use that to determine kind of the value of the energy that we save kind of going forward our next triennial. So it's a little bit of a circular process in order to define kind of like when that energy is being saved and kind of when are the most valuable times for us to acquire more energy efficiency through our eco plan.
Yeah, that's why I strongly share the concern from the Commissioner Partridge on that issue, that when we have a misperception or certain test is misleading this information, we have a huge problem in the resource plan process, because a lot of our cost-effective energy efficiency will be dismissed in the ILP process. So that, I know we don't have a jurisdiction over that, so we cannot say much about it. But that's, I share the frustration that Commissioner Sullivan also mentioned. Yeah, that's affordability too. Why we are dismissing that? Because we have different metrics for the cost effectiveness. In my view, I think ILP process itself can advise or inform us a lot, because the capacity and energy, I agree with the problem with decreasing energy marginal costs, because of renewable, we do not pay to produce energy, but we procure a lot of capacity. So rather than marginal energy costs, we should focus on levelized cost of energy, because which will include both capacity and energy, which will reflect the better value of the solar and wind, which is our direction as a state, because we have that mandate. So now that's why, rather than argumenting that the incentive percentage, I think we should go better and find better metrics to reflect and link both ILP, eco, and incentive, because I think that way we can introduce as much as possible most cost-effective energy efficiency in the ILP process. Because we approve a lot of incentives, but also it should be reflected properly in the resource plan. So that was my concern, since I'm new to this eco, but I only focus on their area, but that just hit me right away. Why can't we just use a levelized cost of energy rather than marginal energy cost, which is converging to zero?
Commissioner Hom, thanks for that question. This is something that we proposed during the Cost Effectiveness Advisory Committee meetings that the department put on over the last year and a half or so. And I believe that docket number is 2689 is the most recent cost effectiveness docket. That's kind of currently the one that is ongoing. And in our comments to the department's proposed decision, we kind of talked a little bit about what we've kind of called the consequentialist method for determining the value of energy efficiency, which is largely, we'll take a look at our IRP and what we have bid in, and the model has selected as the energy efficiency bundles. And we will take a look at what the model would have built if we did not have that energy efficiency and compare that to what it chose to build with that energy efficiency, to look at, say, kind of what load or what resources are we kind of removing from the system, right? And looking at that avoided cost, which then we would use kind of a mix of levelized costs of energy there for, say, the like wind farms or solar farms there, or there is also potential that it would show like firm dispatchable resources on there. So whether that's a battery or other dispatchable resources, we might look then at the marginal cost and kind of blend in a portion of that as well in order to develop kind of this weighted average methodology. It's a little bit in the weeds there. So I think the other thing I would say for that is we would look at that for one way for energy efficiency, but then as we continue to grow our electrification programs or efficient fuel switching programs, we would look at kind of that similar idea of removing the BE from our forecast, beneficial electrification from our forecast, and looking at what resources the model chooses not to build then versus when we have that in the forecast, and look at what resources our beneficial electrification measures kind of induce on the system as well. So that's kind of what we had proposed in this most recent filing, and there was some discussion on it in that cost effectiveness advisory committee, but I think more discussion was needed in order to move that kind of across the finish line, and that's something that we had kind of requested that we look at for the next triennial as well in our comments there, but something that we're certainly thinking about there. And there's a few papers in our comments there that kind of talk about this from a more national perspective as well.
Okay, thank you. And also along the line, because if you use a nameplate for the wind and solar, prices going down because of technological innovation. But Xcel Energy and all other electric utilities should have capacity based on accreditation, not the nameplate. So that's why I think that this disjoint of prices going up because accredited capacity level is going down with the same level of nameplate price is going down. So that's why there is a lot of potential misinformation along with it. If you are just taking this number as it is, we used to do it. So that's why I think we have to see this in more a holistic approach through the IRP process rather than we have a disjoint process, having different metrics in one place and we implementing in another process, and we are giving incentive in third different metrics. So that's why, to me, I think, yeah, I'm not going to suggest anything as of today, but I think we have to be more cognizant about this issue, nameplate versus accredited capacity, marginal cost of energy is going down because our main focus is renewable. And then we're also we want to make sure that we implement as much as possible of energy efficiency because it's an affordability tool. So hopefully we have a better discussion in the next round of the ECO, unless you have any modification in this.
I do not have a suggested modification. I appreciate that. I think there's always been a bit of a issue with the difference between how we value things and how we select resources in the IRPs. Gas utilities don't even have IRPs, although they will, and that'll be a new issue. And Dr. Lieb and Mr. Fryer, I am sorry, I don't mean to be so worked up. It is just that as a commission, I think all of us are feeling immense pressure to try to help the people of the state to afford their energy bills. We know that energy efficiency is the one tool we have that permanently reduces people's bills and allows them to live in their house without having this burden over their head. And now, more than probably my entire career, I feel like this is when energy efficiency should be valued at its highest. And I'm seeing numbers that in my career are their lowest. And it is just really difficult for me to not get a little too worked up about it. So maybe you have some information you could share on how you're continuing to consider these costs going forward.
Dr. Lieb.
Chair Tuma, Commissioner Partridge, on the cost effectiveness test, I think we agree with the commission. The way this has been done historically is not meeting the moment on the volatility that we currently have and the rapid increase in rates that we're seeing in terms of rate inflation. And we will take the critique back. I think there's already ongoing discussions in the Cost Effectiveness Advisory Committee, and we will figure out, I think the entire energy system in general is trying to figure out how to deal with cost volatility. We're seeing this in IRP decisions. We're seeing it in RFP selections that grow out of IRP decisions. We're seeing substantial changes to the MISO market to have better pricing that matches what the actual cost of capacity at peak time is. And I think we're dealing with a different energy system, and doing things the way that we've done them historically is not necessarily going to get us the right answer here. I think it's important to recognize, though, that this is not the only tool we have within the state to manage affordability. We also need to look at how we're utilizing the capacity that we have on the distribution system to make sure that those resources are right sized, and I think our team's really excited to dig into that this year and other dockets. We have our first iteration of the grid enhancing technologies reports to make sure that we have good utilization of the transmission investments. We have opportunities for significant ROE reform. We know that ROEs are probably on average about 2% higher than investors need them to be in order to support utility investment. ROEs typically 15 to 20% of a customer's bill. So I think it is true that the cheapest megawatt of energy is, or kilowatt of energy is the one you're not using. And this is a really important and effective program, and we're committed to working with stakeholders to make sure the cost effectiveness tests are better. But I think we need to acknowledge there's a lot of places across the energy system where we can be working on affordability, and this state really has a lot of sort of leading edge opportunities for us to do that. We're one of the few states in the country with grid enhancing technologies reporting. Our IDP reporting has national recognition on a regular basis, and we are a leader in having low cost renewable energy on the system. We also have the data center tariffs coming up, where we've also received national recognition on our attempts to protect ratepayers from large customers coming in and the stranded asset risk if those customers don't show up in the way they expected. So I think we're selling ourselves short to say this is the only affordability program we have in the state. We have a lot of tools in our toolbox, and the department is committed to using all of those to their maximum effectiveness, including working more effectively on the cost effectiveness. We hear that, and we'll work.
I need a recess.
Recess. How long? 10 minutes. We will come back at 2 o'clock. Okay, we're back from recess. No, we're not back from recess. Now we're back from recess. I'm going to go to Commissioner Sullivan.
First thing is, I'm glad we had the conversation we just had there. And one thing I am concerned about, I am a little bit relieved that everybody seems to be, I hear from the utilities and I hear you say, we can do this, we can work through this. This is not, I don't hear the kind of fire and brimstone. But one thing I do worry about is over the next 3 years, if you're not as incented as you need to be, or if you're not as incented as you could be, if things are getting harder, and I recognize the baselines are going up, I'm concerned about the net benefits cap number. And I guess, Commissioner Partridge, I see, like, with the net benefits cap, I'm wondering, you have increased, you got 5.6 for, I was kind of thinking more in the 6% number. And quite frankly, I was thinking that because I want to make sure that energy efficiency continues to be the vibrant program. And I do disagree with you, Dr. Lieb. I also want to say I never did say the only affordability program. I said the main affordability program. But I want to, and I see here with, with net benefits cap for decision option 20, you have, 6.8%. I'm kind of curious, Commissioner Partridge, how amenable you are to moving those up a little bit, or what you're thinking is, do you think that's the right number if the porridge is right?
Thanks.
Mr. Partridge.
Thank you, Chair Tuma, Commissioner Sullivan. I am open to moving it. I think because we have moved this process up, we don't have numbers where we can see, if in 2024 we had this cost effectiveness framework, where would we have fallen? We're kind of doing this in a different order. It's very difficult to say what the calibration point is. I think more importantly, these targeted metrics are really incentivizing utilities to focus on the specific streams of benefit that I think are most critical for everyone and for the state. And so I'm perfectly comfortable moving it up. I would note if you need help, because the way this works, there's sort of a cascading.
It's like a string. Yeah.
You pull the string, and the sweater
Sweater's
starts
gone.
unraveling.
You're
So
standing naked with all the sweater.
yes, it's the song. Mr. Mark has said he has some idea of how to do that without unraveling our sweater, if you want to talk through it.
Sure, I'd be interested.
Yes, Mr. Mark.
Thank you, Mr. Chair. Commissioner Sullivan. It seemed to me that one can preserve the policy signal that you're trying to send to the utilities, and the emphasis on the different subcomponents. If you basically just distribute, if one were to say, just making up numbers, trying to move the cap from 5% to 5.5%, simply increasing the sub-metric caps by a proportionate amount. So basically distributing that probably evenly is the easiest way to do it, but if you wanted to emphasize one of them over another, you certainly could. I believe, if I'm remembering right, that the initial, I think the weighting the joint commenters put it was something like 60-20-20. Again, subject to correction there. But by following that weighting, you could sort of distribute the additional basis points such that you'd retain the weighting of the individual components and increase the overall cap. Now, taking that approach does assume that you'd be looking to approve individual metric caps rather than a single overall cap. But the way I read Commissioner Partridge's decision options, it seemed like that was the inclination anyway. From Xcel's perspective on that specific point of individual versus overall cap, I don't think we feel real strongly. There is an additional degree of flexibility with just a single overall cap, but it's by no means, a rock that everything is going to founder on if we make a different choice.
Okay. Dr. Lieb, do you have a response or a thought?
Chair Tuma, Commissioner Sullivan, the department is okay increasing the cap as you're discussing, but we think it's important that the credibility of the metric will be lost if we have individual caps and flexibility between the individual metrics.
You're okay raising the whole shore, but you don't want to undo that kind of, here's one for this one, and this one.
Right.
Okay. Commissioner Hahn.
Thank you, Chair Tuma. So relate to that issue. So you have to help me once again. I'm new to this ECO. So what is the relationship between this net benefit cap to cost-effective metrics? I'm nervous about giving you a higher cap unless it can motivate and change cost-effectiveness cap or the metrics threshold, because without that, we may not increase any efficiency by giving you more chance to earn more money without increasing energy efficiency. So that's why I'm a little bit nervous about not knowing the detail of how these two play together.
Mr. Mark, that's a good question, yeah.
Chair Tuma, Commissioner Hom, I understand your question, and as I think Commissioner Partridge alluded to earlier, we are, because of the timing of this, we're in a slightly different position. In the past, we would have said, if you raise the net benefits cap, that means we get a slightly bigger slice of the pie, and that's great. We're just going to implement that much harder and try to exceed the goals that we've already filed. Here, I think the response would be similar, but more around making sure that our portfolios are pursuing the level of, for example, air sealing and insulation savings that would allow us to maximize our portion of the net benefits for that metric, rather than, so for example, rather than saying we'll do enough air sealing and insulation to get 1% because that's all we can get from that, we'd go further and say, well, we can get up to 1.5%, so let's go for it. And whether that's through increased rebates to customers or simply just more marketing or tightening homes further and verifying that those, in some way that you are in fact getting real savings there. Your question was about net benefits versus cost effectiveness. I'm not certain if I answered it.
Yeah, that gives me more concern, because now you can potentially work for less cost effective, while you have to spend more money to induce more conservation because you have a higher incentive. That's why I had a concern that not linking your incentive directly to Minnesota test. Without linking that, potentially there is a problem that we are just giving you too much incentive, then you can work on something because you will be paid for the conservation expense. So that expense can go more than should be based on cost effectiveness test.
Thank you, Chair Tuma. Commissioner Hom, I understand. Hopefully I can allay that concern. The incentive mechanism is indeed linked directly to the Minnesota test. The net benefits that the mechanism allocates a portion of to the utility is the net benefit under the Minnesota test. That is, so all of the value of all of the savings, whether of carbon, of energy, of capacity, whatever it might be, less the cost of running the programs, we take a percentage of that remainder. So if it costs us more money to get more energy savings, comes out of our incentive proportionately. So we're absolutely incentivized to get as much savings for as little cost as possible.
Okay, thank you.
That's assuming the Minnesota test is giving you the right signals to go forward. And that was one of the other concerns that you had. But that's another discussion that we worry about because it does, and that was a conversation we had, feeds into the IRP decision where we could be undervaluing the value of these programs in the IRP. And that's what we're concerned about. That's the magic sauce that makes our IRP cost-effective, low bills nationally work, is this whole recipe.
And Chair Tuma, if I can add, I think the other piece is that the amount of energy efficiency that is encouraged under the ECO framework comes out of the load that we have to serve on the IRP. And so I think there's two different concerns, but my concern is if we undervalue that through the ECO cost effectiveness framework by picking a too low cost of gas, by undervaluing the avoided capacity value, then we're just not getting the true amount of cost-effective energy efficiency, and we're building and investing in whether it's a gas plant or GETs that we don't need because we're not doing efficiency to the level that we really should. So, and I think I'll just say, we only get to pick the financial incentive, and I'm a bit concerned that, us trying to overcome that concern, it isn't necessarily effective. I mean, at the end of the day, if they run the cost effectiveness tests and there are high value measures that just don't pass because we're not running the numbers correctly, because we're undervaluing the avoided costs, then this incentive is not going to overcome that because it's based on the Minnesota test.
And I'm glad you mentioned this, Commissioner Partridge, because I was literally thinking what's the brute force way through the low numbers that we're going to get out of the Minnesota test. That I'm concerned that we're going to, because in particular that natural gas number is much lower than what I think is the reality. I'm just thinking, well, how do you brute force your way through that and still have effective and robust programs?
Yeah, one of the things I thought was missing too is I would have liked to see, because there was a lot of discussion about, well, here, and the utilities said this, here's what we would get under the new system based on what we did before. And I think what would have been helpful is to say, okay, what if you did everything to get over each of those three caps? What would you have done, and how would you perform, and what would your return on that? And so I was struggling with how the new system would work and whether those incentives were going to be enough, because if you actually would meet all of the three caps, your three goals, it would be a pretty good incentive. I think if you go to your C-suite and say, hey guys, we can get 25% return. I know it's not quite that when you work it out, when you're talking about overall utility cost savings, but most people in the C-suite would say, you mean I get return? I get to get that money back in my budget through the rate case, and I get 25% return? Oh yeah, that's pretty good. Go do it. But we don't know if those tools, those mechanisms out of the Minnesota test are quite right. And your mind would spin if you saw my whiteboard right now. I was trying to get that all in the right place, and it took me a while to get that Minnesota test in my brain where it needed to be, and it really is a critical part of it because of that cost of capacity going up so much as of late, and that's what's going to drive our IRP, and so that's a big concern. And I guess it's something we'd probably watch as opposed to the brute force that you're talking about.
And
Commissioner Partridge.
Thanks. Chair Tuma, I think one thing I also want to say is, first of all, and I've said this, I think Mr. Fryer's team does some of the most important work in the state. And I don't mean to be, I actually do feel quite bad because I do think your team does really great work. I want you to know that. I do think that, as Dr. Lieb said, these comments will be considered. I'm sure the utilities have been providing feedback to the department on the proposed decision. That docket remains open. So, Mr. Zoet does fantastic work. I know that things have changed dramatically from the previous triennial, the triennial before that. And so now we're facing a very uncertain future with a lot of volatility, and there is no great way to capture volatility within forecasting mechanisms. And Mr. Merck is laughing because I think that we had this conversation in like 2012. I do want to trust in that you guys are going to figure this out as much as one can. It's impossible to figure out. I think it was, Hurricane Katrina, made gas prices go through the roof, and we spent an entire triennial with like $13 gas when it was really like $5. So things happen, right? But I want to trust in you all and in your team, Mr. Fryer, to figure this out. I also want to say one thing that I had been thinking about is this is the incentive plan. We will approve an incentive plan, and then we can, and I should have asked the attorneys before I said this, but I think we can, make adjustments over time. If we find that, in fact, we are seeing $12 gas and we, need to make adjustments, I'm sure we can find a way to do that. I think, even this recent war in the Middle East, we aren't even talking about the impact that will have on costs. Speaking of uncertain events. So I just wanted to say that we don't have authority over this, and there's a reason for that, and we will trust in the team that does this work and the comments, the feedback they get from their parties. And I think because we're doing this in a little bit different order, I think the 5.5, 6, I want to make sure we have robust incentives, but at the end of the day, the idea that people within the utility might be able to come to the C-suite and say, we need to invest more in insulating people's homes and reducing their heating load by 29, 30% forever into the future, and that is something that would be attractive to the C-suite is, just an incredible step in the right direction and a great way to align what's good for Minnesotans and good for people and what's good for the utility. So
I think we got the big picture. I understand it a lot better. So let's get the nuts and bolts down to a final decision option.
Sounds good.
I know 19 was talked about, so I want to make sure we cover that, and then I'm going to go and see if there are any other fine details that you would like to work on, Commissioner Partridge.
Yes.
So CE, state your name for the record.
Chair Tuma, Commissioners, Mariko Yatsuhashi with Center for Energy and Environment. Just to clarify, our revised decision option 19B was intended to be a clarification more than anything, and just ensure that the definition for permanently avoided demand in the decision options aligns and reflects what was shown in the record.
And I heard a couple statements of support for that. Any concerns in the negative from any of the parties participating with regards to the 20 or 19B changes? I'm not seeing any concerns. Commissioner Partridge, I'll let you work from it from there. So good. Okay. Any other things that you want to just fine details on your options?
Yes, thank you, Chair Tuma. To Ms. Yatsuhashi, I don't even remember which decision option it is, but with regard to whether the current air sealing and insulation metric should or should not include windows, can you give me your thoughts on that?
Chair Tuma, Commissioners, thank you for the question. CEE prefers to keep the metric defined as air sealing and insulation, primarily because we feel that those measures are most in need of a specific call out through a separate metric in the gas incentive. While we recognize the importance of windows and want to see those continue to grow as a program area, we've found that they have additional co-benefits that are visible to customers, and such as aesthetics, functionality that insulation doesn't have, and makes insulation a challenging metric to implement. But still a really important source of savings for customers. So I think that's our logic behind keeping a slightly narrower scope on that metric, is just focusing that attention on those key measures.
Okay. And Ms. Yatsuhashi, what are your thoughts on Commissioner Sullivan's idea of whether about raising the net benefits cap for the gas incentive to 6%?
Chair Tuma, Commissioners, I'd say we understand the complication with the timing here. I think ideally we'd have a better sense of how the net benefits could shape out. I will just kind of reiterate that our intention when calibrating both mechanisms throughout this whole process was to kind of aim towards around where incentive levels have been in the recent years and give utilities room to grow as they kind of achieve higher in these metrics. And I think I would caution that our concern when it comes to raising the overall net benefits cap is primarily that kind of there would be slightly less of an incentive to move up the ladder of achievement in each metric, if that makes sense. So just raising the cap would also raise the percentage that's paid out at each lower rung of the achievement ladder. So through the calibration, I think, again, recognizing that this is complicated with the timing, but our goal is to balance the need to kind of keep that motivation to move up the ladder, but still have a healthy incentive.
Commissioner Sullivan, any addition on that? Or
no, that's good. I just thought it was a good conversation, so it was helpful to me.
Okay. Commissioner Partridge.
I don't have any additional questions. I think I'm looking to you, Commissioner Sullivan, if you have thoughts on that calibration point, because as I said, at this moment, I mean, I'm wide open on whether we keep it at 5.5, 5.6, 6. I mean,
I'm comfortable with where you landed initially. I thought that was a good conversation. I appreciated hearing all the perspectives. So I'm actually quite comfortable with what you proposed initially here.
Okay.
Yeah, we joked about in one of my briefings. It's like calibrating the little knobs, and it's like, this is a nice fine calibration. But I think it's the right direction.
And I mean, I thought about it just like I said before. I'm concerned about the inputs in the cost effectiveness test and where that's taking us. And I'm just thinking about kind of the brute force, like, well, how do we make sure that this does not slow down the train? And I got a good enough answer there. I feel comfortable.
Okay.
Okay. Anything more? If not, we ready for...
I have one more thing I want to say, that you initially said if anybody would write the history of SIP, and I just hit my head that Ms. Eichten, in fact, did do that at some point, and she did a really nice job. So I'll try to dig that up and send it your way.
Thank you.
All right. Do I need to walk through all the decision options, or can I move my
I think you can just move yours.
Okay,
and
with them.
Where we got additions, we'll just go to those.
Okay.
Additions or changes.
Okay. Perfect. I am going to move the March 11th, 2026, 11 a.m. corrected Partridge preferred decision options with one modification, which was to swap out the 19B included in the draft motion with CEE's revised decision option 19B.
Excellent.
And I don't think there's any other modifications to the draft motion that I know of.
Order writer, you good? Good. I figured you were. You usually are. So.
Right.
With that, we have the modified decision option proposed by Commissioner Partridge on March 11th at 11 a.m. The corrected preferred decision options with 19 modification. All those in favor signify by saying aye.
Aye.
All those opposed, same sign. Motion passes unanimously. Being there's no other business before us, we are adjourned. I'm getting this thing away from me as soon as possible.